1, 2, 3.
August 167. Okay, so the letter now issued by the ministry is 167.
Assalamualaikum, hello, and good morning, everybody. My name is Hussam. I'm an architect and also a PAM council member. And welcome, everybody here at PAM Centre and those of you viewing. Uh, it's great to have you join us today. Today, the PAM Professional Practice Forum 13 is brought to you virtually in hybrid mode. This is the first time ever the PAM PPF is done in this manner. And it's amazing to think that this is possible since the PPF has always been about large crowds. And thanks to the advancements of technology, today we hope that this event can reach even a broader audience virtually. We are streaming live via Zoom and also Facebook, brought to you by Garis Pixel. It has been exactly 8 months since the MCO was announced, and it has been a challenging time for all of us. One sector in particular is the construction industry. Over the past months, there have been a lot of confusion, uncertainties, and also frustration across the board. A lot of people have questions, and most of the questions are left unanswered. So the PPF this year hopes to be able to answer, if not all, most of those questions. Today from PAM Centre, we bring you the topic, Surviving Post-COVID-19, a Common Sense Approach. We are delighted to have with us today a very strong and powerful lineup of panelists. I will spare their introduction and let the moderator do the honors in just a little bit. For the opening remarks, I would like to invite Datuk Architect Ezumi, PAM President, followed by the PAM Practice Committee Chair, Architect Anthony Lee, to do the introduction. Ladies and gentlemen, the PAM President.
Assalamualaikum and good morning. Thank you, Architect Usam. Okay, to the audience out there virtually on the Facebook and also Zoom, welcome to this seminar today. I hope you will learn from our discussion today. And good morning, Ya Arif, Datuk Mary Lim, Ya Arif, Datuk Lim Chong Fong, and from REDA, Datuk Engineer Som, Mr. Chung Hong Ling, RDL Partner, Datuk Architect Tan Pei Eng, PAM Past President, Architect Joseph Tan, also a very active member of PAM Professional Practice Committee, Mr. Oliver Wee, MBAM Vice President, and of course, my friend Architect Anthony Lee, the Chairman of PAM Professional Practice Committee. First of all, I have to say that I must thank both the honorable judges for accepting our invitation to be here today. And our audience, our members, you are lucky here to have both of them. And of course, we have a lot more speakers here with me, including Mr. Ronnie Martin, also will be joining us on the second session after the first session. And we have, of course, we have a few more speakers after that on the second session. And as we all know that due to the pandemic, actually almost our construction industry was affected very badly, and everything was almost stopped since March 2018. And recently with the Gazette of COVID-19 Act, I think there's some confusion among our members and also industry players, whether the temporary suspension of the contractual right is going to suspend all their right to take any legal action, or whether even with regard to claim, extension of time, loss and expense. And a lot of discussion out there, and I think that even our members also keep on asking me, so what are the direction of PAM? And just to share with members and also the listener out there, we have several sessions, discussion with REDA, Master Builder Association, through our building industry President Council, that I think we have to already look into this and give a guideline to our members as contract administrators. And from the previous press statement that BIPC had made, we agree that we should take a common sense approach rather than imposing a strict contractual right. So it means that if we can mediate, if we can come into the middle ground to resolve the issues, the dispute among the contracting parties amicably, maybe that's the best approach that we should do. So I do not wish to take much more time. So I think after this, I hope you can stay until the end of the session. And please, if you have any question, post your question via Zoom or also from by Facebook. Then our moderator will pick up the question. So I invite Architect Anthony Litti to give a little bit introduction and background of this program. So thank you very much.
Good morning, my esteemed moderators, expert speakers, panelists, colleagues, and everybody on Zoom and Facebook. Welcome. Germany is in lockdown, and then Netherlands next. London now has a mutated strain. And here in Malaysia, as we all know, the clusters are deep within our community. So this is something that since 13 months ago from Wuhan, it's just bouncing around the world. And it's become a part of our lives, a regiment. Okay? And just yesterday, you know, the CMCO here has been extended to the end of the year. Hopefully and cautiously optimistic of access to the efficacies of these vaccines. One thing that I think we can all agree on is that our livelihood, or may I put it, the business of our livelihood must go on, regardless of how inadequate the COVID Act is. We should take cognizance that this pandemic has emerged from the back of many challenging years already, since 2017, where the property industry has already had a lot of issues with cash flow. With razor-thin margins. I'm sure some of you know this term, parang contracts. Disputed claims through CPAR and arbitration in courts. Professionals are in the same boat. An internal PAM survey conducted by Dr. Ezumi, sometimes in May, during the MCO, showed that professionals only having about 3 to 5 months of cash flow reserves. So by now, I think they've all but all dried up. With empty coffers, are we expecting more government intervention? Or is this the proverbial nail in the coffin, like the deer caught in the COVID-19 headlights? Surely we must help ourselves. In this context, the Building Industry President's Council, BIPC, acted swiftly and encouraged common sense approach in completing projects and advised contracting parties to avoid messy disputes. Put simply, parties should look at ways to complete the projects based on common interest over contractual rights. Naturally, the role of architects have come into prominence as contract administrators of the widely used PAM Form 2006 and 2018. We must take it upon ourselves proactively in averting disputes, bringing aggrieved parties to practical settlements and projects to an amicable completion. However, is this just wishful thinking to expect, benevolence over self-preservation under these extreme circumstances? When money is already too tight to mention, is it not expected parties having the contractual upper hand to dig in? Or do we have happy stories to tell? Be that as it may, in this armistice of sorts, as the COVID Act has provided, should we all be practical over the practical settlements? To this end, I welcome the brilliant minds and speakers and expert panelists of session 1 to begin the uncomfortable conversation and distill these Kesabana stories. Are the prevailing building contracts adequate in addressing future awards by coming to terms with the new norms and SOPs? Or are these risks merely being passed further down the food chain? For this, I welcome the best minds and experts in session 2 to explore and present workable and practical solutions. Unprecedented is the word of the year. For the sake of humanity and the livelihoods of millions in our industry, it is my passionate hope that we can ignite something good from setting something of a precedent here on common sense. Over to you, Mary, the moderator for session 1. May I hand over the floor to you? Thank you.
Thank you so much, Anthony. And you have quite certainly set the stage this morning. Good morning, everybody. I hope we can hear each other loud and clear. It's quite an experience to come back. By year end, it will be 288, 287 days since we've had our first lockdown. It is it's actually almost surreal to be here in this place, because I don't think we've had this experience for a long, long time. And I assure you, PAM has taken every measure to make sure that the place is properly sanitized, that we're all keeping our necessary distances and making sure that all SOPs are met. We've started on a very sober mode and a sober note. I'm going to add on to it that we've had some very, very cold facts that we have to confront. We've had an MCO that was extended. We've had CMCOs that have been extended, and similarly, the RMCO. These all worked out, as I said, by year end, it will be 288. I think the Chinese in many of us would like that 288 used in other meanings. Unfortunately, it's 288 by year end. If you like, then you may keep it at 287. Construction industry, unfortunately, has not been listed as an essential service. So it has been so hard hit. And I think the other problem is the unprecedented events of the last year has aberrated all distinction between our working life and our homes. And such that we've all been into our little holes in some way, bringing that work home. And I like to think that the construction industry, PAM in particular, and the master builders and radar have all gone into their individual hibernating holes, but have not kept quiet and have soldiered through these months. And in those months have now come to a realization that enough is enough. That while others are trying to help us, it is time that it helps itself. So how do you do the work? How do you pick yourself up to not let it be a new norm, but that you control that new norm, that you write that new norm? These experts have sat down and said, I am not going to be dictated. I'm going to write the lines. I will look at what I have, and I will look and see what I can compromise and what we will have to do and to do together. I see this as a very admirable stance. All this against some legislative backdrop which really is, in a sense, temporary, because it is entirely up to the industry how it wants to write its norm. It takes charge, it takes control back again. As Anthony said, the cash flow essential service. Unfortunately, as I said earlier, unlike some jurisdictions, it is not in this country. So we are where we are, but should we continue in this same state? Should we just look at legislation? Should we turn to the authorities for help when the clusters are in our own backyard? The ramifications are horrendous, but it is heartwarming to hear that you have been in your little holes working feverishly to make sure that you take charge again. And so, to set us off, let me welcome the first expert, the brilliant mind and the best mind that Anthony talked about, Dr. Som, who rose from the ranks, who, from his Strathclyde days in Scotland, I think those hard winters have taught him real and well, that he's going to share with us how that C19, most people have referred to it as COVID-19. I tend to refer to it as a C19 in comparison to other Cs, how it has impacted on the property industry. And then after we've done with Dr. Som and he's learned, he's shared with us his learnings, we will then look at Oliver, who will then tell us what his wish list is before we turn to the most brilliant mind in this room, the iconic Datuk Tan, who will tell us how she has been rewriting quietly in her own space our new norm. So Datuk Som, this floor is completely yours now.
Very good morning. Firstly, I'd like to thank PAM for inviting me. I'm no expert. After all these months, I'm still trying to come to grips with this COVID-19. As you're aware, this pandemic is still amongst us. It's not over yet. A gentle reminder to everyone that the way I see the movement of people the last 2 weeks, it's actually frightening me. I think we still need to remember that COVID-19 is still among us. And I think the emergence of cluster at construction site is also a stark reminder to us to say that the pandemic is now beginning to hit us hard. Okay? And this is a fact that I think I want to put forth among the listeners who are mainly the professionals from PAM and maybe some of the radar members as well. How do I go about this? Let's put the slide on first.
You need to start the slide.
Start the slide. Okay. The impact, as mentioned by Yang Arif Datuk Mary Lim just now, I think the impact on the housing and the property industry has been tremendous. And annually, I think our annual sales for the primary market is about 30 billion ringgit. Okay? And the amount of construction work that goes through the system as recorded by CIDB and also the Department of Statistics is in the region of 150 to 200 billion annually. And I think the part that I want to highlight here is that the industry employs 1.4 million people. We pay 40 billion in ringgit in salaries annually. And loss due to the pandemic in the first month when we had the total lockdown under the MCO, I think this is a fact and mentioned by the Minister of Works. It's about 11 billion in a month. Okay, and it has a direct and indirect impact on another 180 sectors and subsectors, both upstream and downstream. Meaning that it's not just people who are contractors or architects or engineers or developers who are affected. The manufacturers who are not actually categorized under construction in the economic pie, they are also affected. The supplier of cement, the supplier of tiles, the quarry producer, they are under the mining sectors and other sectors. So we have a big multiplier effect. And when we look at the whole industry, we have a relationship that goes beyond just a one-party relationship for developers. And here, in the absence of a force majeure clause within our standard sales and purchase agreement, there are a lot of practical issues which both the developer and the purchaser would encounter if unresolved, and would lead to unnecessary challenge by both the parties. So, and the other thing that we need to take cognizance from the lesson we learned during the pandemic is that, as mentioned by Datuk Mary just now, construction is not an essential service. So we will not allow to continue working. But then very quickly in the first week of MCO, we did approach the minister of in the PM's department to say that this industry is very important because it has a big spillover effect. And we requested that we be the next batch of people that be allowed to come back. So in early April, we had a few meetings at the Ministry of International Trade to allow us to come back. But the process of getting us back on our foot was a bit too long. And they don't understand that we need to empower the whole supply chain in order that approvals are not truncated and we can actually get on with work. An example is that, when we submitted approval to recommence work, some contractors got approval, but suppliers did not get approval, or professionals like architects or engineers, they didn't get approval. So that caused a serious delay in us going back to sites. And the delay in the supply chain and the longer period to achieve the optimum output as well. We will ask to comply to SOP. We were allowed to only operate at 50% capacity. So we will never achieve the optimal output that we desire. And this will actually cause a delay to both the contractors and also on the developer side, we will not be able to deliver our properties on time to the purchaser. So given the hardship that we are in, is due to no fault of any one of us, of any of the contracting parties. Our call, as mentioned earlier by Mr. Anthony, is to prevent the disruption and livelihood of the people and the businesses, as well as for economic survival. It is crucial that we don't take advantage of each other and don't throw the books at each other at this current time. Just to highlight the impact, how it impacted so seriously on the construction sector. I have a pie chart here, a histogram here on the left that shows the construction sector decline in the second quarter. These are economic figures, published figures, decline of 44.5%. Versus you look at agriculture, services, manufacturing, and mining. Even mining is doing better than us. We are the worst hit. And with that, you can see that on the right-hand side, the graph shows the drop in property prices. Q and Q, we are in the negative territory. That means Q1 to Q2, we are minus 0.7. Year on year, the growth has also moderated substantially. You can see from the thing on the right-hand side here. In the early part of April, when we heard that Singapore were enacting their COVID bill, we actually, in our discussion, in Reda's discussion with the ministers, two of the ministers, we actually highlighted that it's important that the government quickly maybe enact an act to actually help us during this difficult period. And we know that the contracting parties will start throwing the books at each other, and some may even take advantage of it. And as early as the first week of April, we came up with a press statement. Reda came up with a press statement to ask the government to actually enact a temporary measure bill to help us out. But I think we all know, I don't want to mention here why it didn't come early. Our act was only enacted on the 23rd of October. After a lot of the events that happened, many of the companies have closed down. Luckily, there were no dead bodies around. A few dead bodies because of COVID, not because of businesses. We did two surveys. One survey was during the early part of the pandemic. And then later on, last month, we ran another survey, which is more meaningful this time around. Because the first one we did in April was the perception. This time around, it already happened. How has it impacted your business? And this slide shows the impact that 43% of the respondents say that they have experienced more than 30% decline in sales, for the period. So you can see how serious it is in terms of impacting their businesses. And 84%, I think this is very important and the topic they want to discuss today, is 80%, 4% of the respondents are experiencing delays in construction progress. And if you look at the pie chart on the right, you can see that the bottom one shows that even with the exclusion period enacted in the COVID bill of 167 days from 18th of March to 31st of August, about 19% of them still expect their project to be delayed. That means with this additional 167 days being excluded from the delivery time frame, they are still not able to deliver their project. So it's going to have a serious impact because there will be LAD as well. And a press statement made by us as well. I think firstly, we make a press statement on this COVID bill in May with master builders. And in November, after the enactment of the COVID bill, the BIPC, as mentioned by Mr. Anthony just now, we actually went out to the press. And one of the statements we say, it's a little too late. But to me, I added on, better late than never. So, but within us, I think in BIPC, we did sit down before that to say that we need to save ourselves in this period of the pandemic. Here, I want to show you a relationship between developers. And there are many contractual relationships here. We have a relationship with the government authorities. Government departments were not open. We couldn't get approval. We couldn't get their people to come down to our site to do inspection. Then we have financiers. Financiers who are not working. They can't release the scheduler payment to us. And for professionals, we have architects. Architects couldn't submit the plan. They couldn't, deliver the plan to us on time. We couldn't do our launches. And so these are things that really impact the business. Of course, supplier and contractors, I have already mentioned earlier on. And most importantly here is actually purchaser. At the end of the day, I think we can see from recent court cases that has been given, I think our courts are quite fixed in their mind that the agreement that we have with our purchaser is a piece of social legislation. So where then is the protection for us as developers? So it's a question that we have been asking, and in this period of pandemic, it's not due to my fault as a developer or due to the purchaser's fault as the purchaser. Coming to the COVID bill, what is in the COVID bill that will help to address some of the issues? To me, a statement I want to make is that this COVID bill has not been properly drafted. Okay? It's a public forum. I still want to repeat this. It doesn't look at the issues of the whole supply chain. Okay, they just look at certain particular parts and then did not know that this part has a connection to that part. Later on, I will just highlight one or two issues that has now arose out of these issues. The other parts will be addressed by Datuk Tan Pei, so I'm not going to go in there as well. And we know that there are 50 over parts in the COVID bill. But the part that is related to us in the construction and property sector is actually part 2. More relevant is part 2, which will be addressed by Datuk Tan Pei. I will address the part 11 relating to the Housing Development Control and Licensing Act 1966. And part 11 has 6 clauses there from clause 32 to 38. Basically, if you look at it, there are only 3 main issues here. If you look at clause 32, it says that these acts come into effect from the 18th of March. That means even though it's enacted on 23rd, it's retrospective nature. It goes back to 18th of March. There's no end date mentioned in this part here. And in section 33, it mentions that it covers those standard SPA under Schedule G, which is for landed, Schedule H for strata property. I and J is more for the completed properties. And section 34 talk about late payment charges, okay, to be imposed. As I mentioned earlier, the period from 18th of March till 31st of August are actually excluded from the calculation of the delivery period. At the same time, is excluded from the calculation of the late payment charges. Clause 35 talks about delivery of vacant possession because of the delay by contractors. So we as developer couldn't get our property on time, and we are not able to deliver to the purchaser. Similarly, the period from 31st of from 18th of March to 31st of August are excluded from the calculation, and there are about 167 days added on to your completion date. Okay. As for LAD as well, so we are, because of this 167 days, so this 167 days will be excluded from the calculation. But developers who are not able to finish, like I showed you the slide earlier on, 19% couldn't complete their project, even though with this excluded period, they can then apply to the minister to have this extended until 31st of December. But the question here I ask here is that, since now we have a lot of cluster at the construction site, okay, whenever there's a cluster, there will be a stop work order of at least 2 weeks to a month, okay, or maybe more. What happens then now? Because this example today, my site have a cluster, it will extend until middle of January or end of January. So it's outside the ambit of this act now. Okay, so what do we do? So these are things that we have highlighted, and we hope that relevant authorities can actually look into it. On section 35, talks about period to be excluded, I mentioned just now. And then on section 36, sorry. Okay, on section 36, it talks about defects liability period. Because developers cannot repair or take action for defects list that has been submitted to them during the period of the MCO. So a similar period has now been excluded of 167 days from the calculation. Even though with CMCO, actually contractors can go back to site and do the rectification. Here lies the problem. Okay, developers will now have to give an additional 167 days to the buyers. But for the contract between the developer and the contractor, there is no such period in there as stated. Okay, unless the learned architects can tell me there is such a thing in the PAM form of contract. So there lies the issue, which maybe we can debate or talk about later on. This is some of the issues where I see the bill is just not adequate, and why it came about, we also did not know. And on section 37, I think that what mentioned, this is a saving clause that we did not like, to say that whatever action that has been taken by the buyer or the developer against the buyer will remain, as if this act did not exist. And because this act has been late in coming, you know, we talked about it in April, but it only get enacted in October, but the draft was flying everywhere. So everybody knew about it. So we were even joking among ourselves. You remember that Master Builders and also PAM saying that this is a time we must now quickly take action because before the act come into play, because we are very safe. We are safeguarded by this saving clause, which I don't think we are all happy about, since it's not due to any of our reasons. And on section 38, it's mainly about tribunal, to say that you can still submit to tribunal, there's an extension. A question that I also want to highlight here is that, of course, if there's any dispute, we can actually refer it back to the minister. But here we have under clause, under section 2, there is this mediation. Okay, but under part 11, a question being raised by my members are, is it under the power, if there's any dispute, is it under the power of the tribunal, or can this be referred back to mediation? But because the mediation part is very specific on certain contract that's being allowed, and for claim of up to 300,000. Okay, our concern is mentioned here. I think I have highlighted some of this comment just now. You know, about LAD and also defects liability period. I highlighted this just now, and period of MCO up to the extension until 31st December. Now with COVID-19 becoming more serious, what next after January, say February, March, if something more serious happen, if there's further lockdown? This is a BIPC statement in the press in November, mentioned by Mr. Anthony just now, and a statement made by me, you can see at the right at the bottom, to urge all the parties to use their common sense. That was at that time. I didn't know that PAM took out the topic of today's forum as well. Oh, it's covered. So beyond 2020, this is a question we all ask. Do we extend the current COVID Act? Because we have the expert here today. Maybe the expert can tell us. I can't find an answer. I've been talking about this topic for the last many months. I think Datuk Ezumi knows about it. Or will there be another new act? We don't know. I don't think so. I'll be given a lesson later on, maybe a 2 hours lesson on this. And adapting to the new normal, what should we do? Mentioned by Mr. Anthony just now. The next session will be talking about what we should do. And moving forward, I would say all industry stakeholders, we are all struggling, still struggling. We all must make sure that we don't use our contractual rights, because this act talk about obligation. It doesn't talk about rights. So now it's like we are asking people, don't use your rights in the contract. Don't throw the book at each other, because we are all facing difficult times. And we hope that all the parties concerned, whether they are developers, they are home buyers, they are contractors, please come to your common sense. And we urge all of them to arrive at a commercial decision. I think I highlighted in the various sessions to say that for those contractors who have a long relationship with developers, I think there are a lot of goodwill. And the relationship between the professionals and the developers, I have lesser concern. Most of the time, I don't know why developers never take action against their professionals. Okay, which is a good thing. Okay, and since we only have balance of 2 weeks in the act, what should we do now? We should urge the government. So under radar, we have actually written into the Minister of Law to relook at it, whether the act can be extended, need to be extended or whatever. And in various engagement sessions, I've done the same as well. So that's all I want to say. And I'm here also to learn. I'm no expert. And thank you very much to PAM for inviting me today.
Thank you very much, Dr. Som. That was excellent. So you've told us about the 167 days which have been exempted. It seems to have protected and freeze-framed that. But still, there is the very important 19%, and it's a significant 1/5 that will not be able to meet the day. And the numbers that you've given us are phenomenal. It's quite I can't even begin to look at it. The workforce here is at a very, very substantial workforce, 1.4 million. And I think today there was a WhatsApp message going on, and it would be wrong of me to repeat that. Safe to say that those are also very strong numbers, because out of that 1.4 million workforce, a substantial number of it is actually foreign labor. And that's where the cluster problem arises. And you have also highlighted the fact that we've got issues with the savings clause, how people have taken advantage of it. And this is a remark that was actually made by a colleague of mine who sits in the Intellectual Property Court, that he believes that the COVID situation actually hadn't dampened the numbers in terms of filing. And this actually explains it, that 6-month window gave everybody the chance to slip through. So exactly how much the act is of any benefit is yet to be seen. You have also pointed out the concerns about mediation, how that interfaces with the tribunal's jurisdiction, whether we work together, and also the problem that at the end of the day, the legislation is only talking about obligations and literally begging people to freeze off, to hold back on insisting on obligations. What about the rights? And I think that's exactly the flip side of exactly what obligations are. And I think you have pointed out that we all have much in common, and there must be some sense out of it. Hence the conjoining of the two words of common and sense. Right. Oliver, you've heard Dr. Som. Are you happy with what he says? How he is silently pleading to you that not a complete answer has been provided in the legislation. A little bit too little and too late, but better late than never. The political man in Dr. Som speaking there. But are you happy with his comments? Do you think that's enough, that the contractors, suppliers need to do their part? Would you share with us, please?
Yeah, thank you, Datuk. Good morning to my fellow panelists, ladies and gentlemen. Well, I think Datuk Som had done a very good sharing on what overall the industry has faced, or even still facing. Now, 2020 has been a very rough year for the industry and actually everyone. Now, the industry was caught very unprepared by the declaration of MCO back in March. And however, most of us were then expecting the so-called pandemic. The disruption was actually a short one. But MCO ended early May, and then with the declaration of CMCO, then followed by RMCO, and even now CMCO until end of the year. Now, work was then only restricted to critical works during MCO with full compliance to SOP. Then the construction activities were allowed from early May with strict compliance to SOP. And then June this year allowed all resume operation. However, delay to resume operation in the industry then was due to some critical factors. There was then the financial issues, confused over SOPs, arrangement for testings, disruption on supply chain as a so-called display by Datuk Zom just now, and also the shortage of laborers. Now, contractors were then put on two main tests since March. Number one, it was our cash flow test. How much one has in the pocket and how long can it last? And many can't survive until June. And many actually decided to quit, especially those smaller ones. Majority were then thought COVID was a short-term disruption back in March. So they're trying very hard to pay part of the salary or even allowance to the workers without any work doing on site. Now, workers can't survive with no salary, only on allowance. So they move on to their other options. And many have actually gone home to their own countries. That leaves us on the next problem where we have shortage workers on site, shortage of workers in the industry. Now, when came June, it triggered a second test, which was our solvency test. How much you have in bank, where your pockets actually run down. So how many people are willing to dig out his piggy bank and put it on to maintain the workers without works? And at the same time, operation was allowed to resume with condition. Such testings are required, social distancing. Now, many subcontractors came to main contractor for funding to resume work. They just wouldn't want to put their good money after bad money, you know. So at that time, the ball was then on main contractor's court. If main contractor were to ignore such a request, so they will lose up all the workforce when time is allowed to start work on site. But how much can one fund the uncertainties where even SOP were not uniformly confirmed by authorities? We are running in and out. We are facing different types of instruction every week. Now, quoting an example on today's situation, productivity easily down by 25%. This is mainly due to the frequent stop for sanitization on site, time for workers check in, check out, long queue for 300 to 500 workers on per job site, where you only have one entrance. These are all under SOP. Like what Datuk Som say, downtime on workers due to close contact, at least 14 days quarantine. For example, like MRT2, average 200 workers are actually on daily lockdown. When it comes to cost impact, each worker will need at least average of 400K a month on testing, PCR testing, if the test were to be conducted once every 2 weeks. Transportation, due to social distancing, one bus seated 20 versus 40 pre-COVID. CLQ house 4 workers per room now, compared to 6 workers before COVID. The bottom line is we are looking at 700 to 900 ringgit per head per month of extra. Putting MRT2 an example, they have 14,000 workers. So we are talking about in a quantum of 6 to 8 million extra per month for operation of MRT2. Now, knowing that contractors are always in the worst position in the whole food chain, we can't see lights now from the other side of the tunnel. We can only face nothing but uncertainties. So I'm here today to bring up our wish list. We are seeking for amicable solutions. At least the contractor is having sufficient time to complete their obligation, to complete their work under the contract. And also seeking for reimbursement. We're not talking about claims. We're talking about reimbursement, or at least a cost sharing. A cost sharing on all this extra that we have not anticipated from the tender stage. We can't see what recourse we have as a contractor. But at least we must know what is our maximum liability to be. You know, so well, I mean, there are parties asking that you can put up claims, but this is something that we want to avoid. It's a long, painful journey to fight. You know, it's definitely sensible to have a good, amicable solution to sit down between the contracting parties to resolve the issues, rather than, like Datuk Zum said, throwing books. So the above is what we need to know in order for a contractor to pull through and to move on. And that's for me. Thank you.
Thank you so much, Oliver. Not only do I hear what you say, but I hear the cry in that voice as well. That wish list is so important. It's Christmas next week, and I wonder whether the industry can at least put something on that Christmas tree. But I think it's quite real. I think at the end of the day, two things come out from your wish list, Oliver, if I'm right. First is, let me do the job still. Let me finish it. Delay is undeniable. But don't change me for somebody else. Keep me on the job and let me finish the job. And I think that's quite important, because very often in other conditions, when there is delay, there is usually a change. So I think here, the first point is let me complete the job. Secondly, the cost from that delay is not something that has been dreamed up, but something that is quite real, and the numbers can always be verified. The situation you shared with us of the MRT 2 situation, and that's just only speaking of one project, is again quite disturbing, but again very real. And I think the second point that I take away from your wish list is not a full reimbursement, but a sharing of that cost. That at least we don't need to turn to the lawyers, to the tribunals, we don't need to turn to courts and get into a different mood. Let's see how we can take care of each other. And this doesn't have to be what Datuk Som said just now about the ones with long relationships. You can make your best relationship even today in your first relationship, so that you come through the storm together. I like to think that it's no light at the end of the tunnel, but certainly clear weather, because you have chosen to put that there rather than see nothing. Right. We've got those two situations, Datuk Tan. And as I said at the very outset, PAM's not been sitting quiet. It has taken stock of exactly its function as contract administrator. You put the forms out there. In your wisdom, you had anticipated force majeure. Whether the current conditions fall within it or not is a separate issue altogether. But more important is that you have taken charge, regulated your industry, your members, but you have also taken stock of the other facet of your professional services, and that is as contract administrators, and that you need to find solutions. this is the, could you tell us and share with us what solutions you have in your center's bag?
Thank you for your kind introduction earlier. Actually, I'm also not expert. Being one of the authors of PAM 206 form and also involved in the 2018 redrafting, I actually realized how inadequate our PAM form of contract is. We never anticipated this kind of prolongation of a situation that really impact the whole industry. So as what both Dato' Song and Mr. Wee, representing the contracting parties, have already highlighted all the issues we are facing. I'm also going to discuss briefly on the issues faced by architect as a contract administrator, caused by this COVID-19 pandemic, and some of our recommendations on the way forward. Sorry, it doesn't move. Okay. So as everybody has highlighted, the long anticipated COVID-19 Act has finally been published only on the 23rd of October 2020. So most of the industry stakeholders are saying not only is too late, it is too limiting, and also is causing a lot of problems rather than solving the problems. So there are altogether 6 sections of the Part 2 of the Act, which I'm concentrating today. So there are 5 sections from Section 5 to Section 10, and construction contract and professional services contract are included under Item 1 and 3 of the schedule under Section 7. So I will briefly go through the sections, but there are 3 important points covered under Part 2 of the Act. Basically, inability to perform contractual obligations, dispute resolutions by mediation, and saving for the exercise of rights prior to the publication of COVID-19 Act. So Part 2 of the Act is deemed to have come into operation on the 18th March 2020 and will expire at the end of the year. But the Minister has the authority to extend the validity of this part before the expiry date, right, by order published in the Gazette. We are only like 2 weeks away. So for this part to be in operation, definitely we need to be extended.
Hello. Can I use the mic instead? Okay, so this act requires a non-exercise of rights for a limited period from 18 March 2020 to 31st December. It is not a waiver. It is also not an automatic EOT of 9.5 months, like somebody thought that, this actually gives you extension. It must be also due to COVID-19 measures under the PCID Act 1988 to control and prevent the spread of COVID-19. So questions has been asked, does it cover COVID-19 overseas? Because as you know, construction contract, you do have equipments being shipped from overseas, right? But those are due to COVID-19 overseas. But our act is very limiting in the sense that it makes specific reference to the PCID Act, right, which is local. Okay, Section 8 basically mentioned the minister has power to amend the schedule as prescribed. And then Section 9, any dispute may be settled by way of mediation. But this is a may provision, it's not compulsory. So the Minister of Law can determine the process, and then upon conclusion, then the parties enter into a settlement agreement, and the agreement will be binding. Actually, under PAM form of contract, we do have alternative dispute resolutions as well. So in the event you have dispute, you can still refer to those contract provisions. Okay, Section 10, as what Dato' Song has highlighted, it's the most troublesome kind of saving provision that doesn't quite work. It basically says that any actions taken by the party in terms of determinations of contract, performance bond, that happens during the period from 18 March until the date of the publication of this Act, 23rd October, are deemed to be validly carried out. So just a reminder, COVID-19 Act only applies for disruption due to COVID-19 measures. So in reality, the rights of the parties under the contract remain intact, right? If the breach is not due to COVID-19.
But with the saving provisions, even with if the breach is due to COVID-19, the actions taken prior to 23rd October are still considered valid. So this means that the effective period of this part of the Act is actually affected by the late publication. So I think Dr. Song and Mr. Wee have covered a lot of the issues that are being faced by the industry. And although PAM 206 and 2018 contract have very specific provisions for EOT to be granted for force majeure, the contractor is not entitled to claim for loss and expense. Our contracts do not have comprehensive provisions to deal with pandemic of this nature and scale. There's little provisions to ensure equitable distributions of risk and responsibility for such a prolonged disruption. The COVID-19 measures actually imposed by the government and the authorities have rendered contract administration extremely difficult. And COVID-19 measures cover not just MCO, but also CMCO, RMCO, EMCO, and all the SOPs, because they do affect productivity. So when there seems to be this consensus regarding EOT to be granted during the MCO period, the EOTs to be granted for the delay caused by the subsequent COVID-19 measures are more complicated and depend mainly on the specific conditions affecting the project and the contract provisions. There's this constant conflict between the contracting parties. And as you know, employer is trying to tell you, you should not grant EOT, you should not entertain loss and expense under the contract. And the contractors are crying out, please help us, please look at reimbursing us on the loss and expense, please give us EOT. So, and then Dr. Song has also highlighted, when there's an extension of DLP for purchaser, there's no provision in the PAM contract to allow extension of DLP. So as you can see, the part 2 of the COVID-19 Act is also not comprehensive and will not be able to resolve all the contractual issues that we have raised, and a lot of disputes are expected. So the mediation process to resolve all these disputes will be very lengthy, costly, and time-consuming, and it's not going to help us. So recognizing COVID-19 as a pandemic that's unprecedented, right, and that has caused major disruption to the building industry, it is very heartening to note that all the building industry stakeholders have decided to come together to address all these concerns. The intention is to encourage the contracting parties to approach the ongoing projects with a fresh mindset by looking at the best way to preserve each other's interests rather than going by contractual obligations and rights. So what I have shown on the screen is the BIPC Joint Advisory Notes that was issued on the 13th November 2020. So I would like to read to you the key recommendation. Consultants are encouraged to play facilitative roles in helping the contracting parties to explore options that will seek to balance their respective interests to ensure the sustainability of all stakeholders and the building industry as a whole. So we need to work together. So these are all the signatories of that joint advisory note. Okay, I would like to share with you Singapore experience. Singapore has recently passed an amendment to the COVID-19 bill on the 2nd of November and came into effect at the end of November. Two main relief measures have been introduced for the construction sector, right, to provide more support. The first relief is to provide a universal extension of time of 4 months, amounting to 122 days to address delay. And the extended completion date will be treated as a new completion date for the purpose of the contract, and no application is required. And this will apply not only to the public sectors, but also to the private sector projects. Contractors who wish to seek longer EOT can still do it, and they will rely on the contract provisions or negotiate with the employer. They can also serve a notification for relief, right, on the LD payable under the contract. The second relief, which I think MBM will welcome, is a co-sharing of additional non-manpower related costs, and they name it as a qualifying cost between the contracting parties due to project delay by COVID-19. So this co-sharing percentage is 50% to the employer and 50% to the contractor. But there's a cap. It's subject to a monthly cap of 0.2% of the contract sum per month and the total 1.8% of the contract sum, but until 31st of March 2021. Again, this will apply to both the public and private sectors project. But in this particular relief, the contractors are required to make payment claims. But in the event there's any dispute, you have an opportunity and file an adjudication application. Okay, this relief measure was introduced to ensure that no stakeholders bears an undue share of the burden caused by the pandemic and minimize the downstream contractors going under, because this could in turn have a knock-on impact on the entire value chain. So based on what has been presented, Singapore COVID-19 Act has much clearer provisions to deal with EOT and the co-sharing of the cost, which our Act lacks. So as PAM being in charge of all the architects and we are the contract administrator, so we have been working on what we can actually recommend to be considered for contract administration, taking into considerations that our PAM form of contract currently does not have adequate provision to deal with it. The first one is on extension of time. So what we are saying is for the project that has been issued, has not been issued with CPC, the contractor is actually entitled to claim EOT under clause 23.8 force majeure for delay caused by COVID-19. So force majeure is actually defined in our PAM form of contract under Article 7, right, which is highlighted in red, and it covers epidemic and also actions by government and regulatory bodies. And we have this, then what we're also recommending, the assessment for application for EOT shall take into considerations of all the delays in the progress of work caused by all the COVID-19 measures, which include MCO, CMCO, and also all the compliance of the SOPs. And there was this timeline that was prepared by the PAM Practice Committee, which served as a very good reference for the period to be considered. And we are also proposing that we should be more lenient with the condition precedent requirement for EOT application. Architects are recommended to assess the EOT application, even if the contractor has not fully complied with the requirement on the notice and also on the period of submission of particulars of delay under our subclause 23.1. As you know, our subclause 23.1 basically says, if you don't submit the notice within the time frame and you don't submit the particulars in time within the time frame, it's deemed that you do not require EOT. But I think during this particular difficult period, we should be a bit more lenient on this requirement. Okay, the second recommendation is on loss and expense. As you, we have highlighted clause 24.3 of PAM form of contract, the contractor is not entitled to claim for loss and expense due to delay caused by force majeure. However, we would like to consider this, recommend this to be considered by the parties, for each party to pay for their own costs arising from COVID-19 SOPs compliance, and employer to bear the cost for the extension of performance bond, contractors all risk insurance, and workmen's compensation insurance under the contract, or the EOT granted in relation to delay caused by COVID-19 measures. Because these are basically, protecting the interests of the employer. Okay, on DLP, I think this one also has been covered, no provision. So, but we would like to recommend this to be considered by the parties. For projects regulated under HDA, DLP to be extended for the period affected by the MCO. But for projects regulated under HDA, the DLP to be extended for the period affected from 18 March to 31st of August to be in line with the period granted under Section 36 of the COVID-19 Act. But this clause actually has got implication on the release of the balance of the retention fund under clause 30.6D. And this should be negotiated, because I think it's also not fair for you to hold on to the entire 12.5%. So you may need to negotiate for partial release or progressive release, yeah. So as I have also mentioned, there are obligations under many clauses of the PAM form of contract. They have time implication, but no provisions for extension. So we are also recommending for the duration of the contractual obligations to be extended accordingly. So these are some of the examples. right? So, and we are saying that the acts of delay in performing all these obligations during the period are not considered as defaults by the party. I just want to highlight to you the number of crosses that are affected by this. As you can see, we have actually tabulated all the crosses affected by the COVID-19 measures. Can you see the number of crosses affected? So as I say, when we drafted the PAM form of contract, we never anticipate, a pandemic of this nature that caused so much prolongation. Okay, so where do we go from here? For ongoing projects, we have decided to issue practice notes, basically covering all the clauses of the PAM form of contract to our members, right, to guide them. And these are the guides for our members to bring it to the contractors and the employers to consider. And all those recommendations outside the provisions of the contract, of course, are still subjected to agreement by the contracting parties. But we are hoping that the BIPC could also look at what we have recommended and give us their support and probably adopt this as a PIPC joint advisory note. And for new projects, we definitely need to make clearer provisions for the tenderers to price accordingly, and also include additional fair and equitable contract conditions to address all the issues that we have raised. And on the longer term, under PAM, we already said we need to review our PAM form of contract, to look at more comprehensive provisions to cater for future pandemic of such a nature. And on the COVID-19 Act, we definitely need to make recommendation to the government to extend the validity because it's going to end soon. And also make similar provisions like what the Singapore COVID-19 Act has with regards to the universal EOT and also probably some cost sharing formula. So I would like to announce that PAM, this is fresh from the oven. We are launching these PAM practice notes on contract administration in relation to COVID-19 Act 2020. What I've shown on the screen is a link and also the QR code that will bring you to the practice note itself for you to download. So please, we hope that this guide is going to help our members, but it's not a medicine that can save all the problems, but at least, it's a guide for our members to move forward. So we hope that all of us can actually work together to make a difference because this pandemic affects all of us. So thank you.
Thank you so much, Datuk. Excellent presentation. Yet another brilliant mind, effortlessly presenting and showcasing the latest notes, hot from the oven, as she says, the advisory note. So the takeaway that I have from Datuk Tan's presentation is the BIPC issuing a joint advisory note on the 13th of last month, where, and I think this is quite important, in very broad terms, but it sets the stage, that the architects now are encouraged to play a facilitative role. And in that role, to remember to balance all these interests and against the obligations and rights. And ultimately to look at sustainability, not just of yourself, but of the industry as a whole. So these broad themes are quite important and is to take away. You also reminded us and shared with us the Singapore experience, an amendment that came as a response to again prevailing conditions in Singapore, where they have introduced a universal EOT clause as well as a qualifying cost sharing. There are, of course, further extensions beyond their 4-month, 122 days. And it's admirable that these extensions in the first phase are automatic, not requiring any application. It is also very encouraging to hear from you, Datuk Tan, that you are ensuring that nobody in the chain bears an undue share. whether upstream or downstream. And you have made very firm recommendations. PAM has been clearing up its work, looking immediate, short-term, long-term, and holistic. Those recommendations, Datuk Som and Mr. Wee, would you be happy with them? And before I pose the question to you, Datuk Tan, is PAM considering in issuing this practice note and these recommendations, expecting its members to come back with a response within a certain time? Because if the members come back with a very positive response, it will surely lead the way for the other industry players, for the engineers, for the surveyors, etc., to also get together and also come to a firm commitment that as members of these particular cohesive bodies, this is where they want to go. Are you expecting, when you send out this survey, this practice note, to at the same time invite your members to respond rather than to have it shoved down their throats, so to speak? Before I ask Datuk Som and Mr. Wee whether they like what you have recommended, please.
Actually, that's the intention, not just a practice note to our members, but we are also proposing for this recommendation to be brought to the BIPC. In fact, we have actually submitted all this recommendation to the BIPC, and we hope to have a sessions with all the stakeholders to look at whether some of these recommendations are reasonable or palatable by all the parties. At the end of the day, like I say, I think we need to work together to find a middle path that can be agreed by all. If we can come up with a joint advisory note by the entire BIPC, it will be actually more effective than us sending this out as a guide note to our members. You know, having the endorsement by the entire stakeholders, I think it's more effective.
Certainly so. Thank you so much. So, Datuk Som, do you like what you hear?
It's good that this was brought up, and I think during the BIPC meeting prior to our joint statement, I was the one who actually suggested that the PAM, I think Datuk Ezumi was there, that PAM be the mediating body amongst the professionals, because they are the main contract administrator and they are the SO of the project. Secondly, I'm quite sure that this practice note, before being used, will be discussed amongst the BIPC member. I think anything good or bad will definitely be objected or supported by certain section of the business community and developers alike. For those who have already got a good relationship with their contractors, they would have sorted themselves out, you know, over the months, who to bear what cost, what to do. Some say, okay, this I don't bear you, this one, can you help me a bit? Can you give me a bit more time? So that is all being sorted out, okay? And there are also a lot of contracts that are being not run properly, in the sense that prior to the COVID-19, they already have issues, you know. So here we must be very clear that it's actually issues due to the PCID Act, Act 342, and nothing else. Anything that is before or things that are not due to this shouldn't be taken advantage of. See, and I believe that when things are clear, I think then the contracting parties can make a decision very quickly. See, a lot of time the contract administrator in the developer side, they'll be looking at their bosses will be looking at their pocket, you know. And the main problem we are facing here, why the contract administrator in the developer side couldn't make a decision, is because whatever decision they make here and the cost implication here will have an impact on the other side, the contract with the purchaser. Example, we are delayed, okay, and now we know that after the Ang Beng Lee case, Regulation 11.3C is ultra-virus, and also there have been 1 or 2 court judgment made, okay, at the High Court level, I would say, to say that the additional time given for us to complete beyond the statutory 36 months for high rise is not valid, okay. But if I have a 55, 60-story building, how am I going to complete in 36 months? So this is the time I'm going to squeeze my contractor and get something back from him, you know, to impose LAD on the contractor for non-performance and all. This is my opportunity as a developer. But there have been questions asked to me as well, and in the public forum. Should now the 167 days be excluded from the 36 months, or can it be excluded from the 48 months? These are issues, these are practical issues that's now happened. And I will say that the developers are also left exposed because of certain judgment that's already there. And because the court always view this as a piece of social legislation, the SPA, it's a piece of so we are left unprotected here. So I would say many of the developers will want to look at the thing in a bit more detail. And I think in our initial discussion in BIPC is that after this practice note is out, we will all discuss and deliberate and then come to the middle ground and then put it up as a guide for everyone. So that you don't come and mess around, and to actually to make the contract administration a bit easier. Otherwise, a lot of people don't make decision, and a lot of people don't want to make decision. So it's trying to help them to make a decision in this aspect. And I think, I've been wearing two hats for a long time now. I've been a contractor, I've been a developer, so I know the difficulty when it comes to this. So when PAM was amending the 2018, so what I did was I throw a book to my construction side, I throw a book to my developer side. Okay, you give me your feedback, you give me your feedback. Because if I ask one party, they will all, do whatever that is good for them. If I ask the other party, they will do whatever that is good for them. So here is like having the middle ground. And I think with the stakeholders all coming together to try to address this firsthand, I think it will be something that we all achieve, that if the government don't want to help us, we help ourselves in this instance.
Thank you. Mr. Wee, I noticed that the moment Dato' Som started talking about this is the time to squeeze the contractors, you immediately furiously started making a note about it. I'm not too sure whether that's for another day or this is to prepare yourself for a retort. Comment please on Dato' Tan's recommendations, and feel free to immediately respond to Dato' Som's comments about squeezing contractors.
Yeah. No. I took a different note because when I heard what Dato' Som say, I would like to remind my fellow contractor not to be too aggressive when you commit on pricing and time. A lot of time you are giving a false hope to your client that you can do at such a low cost and you can do within such a short time. So these are unrealistic. Now, from what have proposed and suggested by Dato' Tan, definitely is a good thing to the industry. I think BIPC level has debate and discussed it for many times. And we also recognize that the PAM, the architect of the project, is the best person to so-called mediate the issues, regardless what is the numbers and time from the dispute. In fact, Master Builder also is a strong believer of mediation. That's why we have our own mediation panel. We are ready to help all our members at a very low rate. Yeah, it is a good recommendation from both datos.
Would that expression, that certainty and confidence, extend to that last subcontractor down that chain? You think that particular person would be able to have food on his table?
I think what the changes and from the recommendation is definitely lighten the shoulders. Well, we got to leave it to individual, whether you want to move on with the risk that you are taking or you call it a day.
So it's a case of whether we're going to look at the half full or half empty.
Right, because like what Dato' Som said, if the government is not helping us, we got to help ourselves.
So you have actually indicated from the discussion this morning, I think what Dato' Ezumi said and what Anthony said this morning is so true. We've got the brilliant minds here, and they actually form the brigade. You know, when you've got an emergency, you've got a problem, you're looking for the brigade, and the brigade is here. And it's a case of you really living up to your job of managing the problem itself. I was a little bit, felt a little bit quiet when the comment came, Dato' Som, that people don't like to make decisions. But that's exactly what it is. Decisions have to be made, you like it or not. And I think for it to be effective, it's got to be cohesive. can this, my next question is, can this go on without any extension? If there is no extension, or if the extension comes and comes again 10 months later, or never come at all, would these recommendations spread, be first taken up by the architects themselves, be taken up next by the rest of the industry? Do you think, Dr. Tan?
Actually, if we look at our current part 2 of the Act, whether it's extended or not extended doesn't really make a lot of difference because the provision is so limiting anyway. And the effective period is also very short. So as what Dr. Song said, if the government is not going to amend a bill or introduce a new bill to have a clear provision like what Singapore has, I think we among ourselves have to work together. And if we are united on this, I really do think that we can make a difference. Yeah.
Would you think the same as well, Dr. So?
I think when we talk about the extension, we wanted the government to look at maybe there's a possibility to amend certain of the clauses like what Singapore did, and then make it universal so that everybody abide by it, like a fixed extension for the contractors. And what are the exclusion, who pays for what, and all this. And here now is like this period of time we are doing mass testing at construction site. Cost, if you are registered with SOCSO will bear the cost. What about periodic testing? This is not a vaccine, You test today, tomorrow you go out, get infected, you come back, infect everybody. So is there a periodic testing? No answer yet. So at a different platform, I have raised this. In fact, the governing body of some of the, for the construction industry is trying to have a meeting between master builders and ourselves. And I think from the onset, the time when the MCO came, as early as April, when I met up with the president of master builders, I said, hey, we need to have a discussion. And then we went online with our members. I think Oliver was also there with your secretary general and all this. And we had a discussion. We already know from onset, it's going to be a problem between the contractors and the developers. And of course, we have other set of problems, which we don't have a body representing them. It's a buyer at large. And, don't take us wrong. A lot of times, these buyers are very opportunist. I think architects will also know. They are difficult people, and they take advantage of the situation. And then now they say, oh, you're not covered. I'm going to come after you. And where is, a lot of my members now ask us, where's the protection for the developers? There's none. On one hand, I need to safeguard my contractors to ensure that they complete the job. Because just now, I think Dr. Mary, you did mention that if the job is delayed, the developer want to change the contractor. I think in 90% of the time, or 99% of the time, the developer wouldn't want to change the contractor because it will take too long, it become very costly, and they has other effects to the quality of the building or the completeness of the work, because they may sabotage the sanitaries, they may sabotage the plumbing work and all this. So to us, to me, I would urge all my members and to accept whatever is later on being negotiated and agreed between the parties, and use that as a guide. Even the COVID bill is not extended and there is no amendment to it. I think we all need to help ourselves to sail to this period and then ensure that we learn from the lesson, and in the next tender or next job that we're going to do, we please do it properly and anticipate whatever kind of force majeure that may come in to the picture.
I see. Thank you so much. Two points that I would like to raise next. First is the universality aspect that Singapore touched on. Most of our contracts actually are not local. It will have at some point some international aspect. Do you think these measures will address that concern? The second point that I want to touch on is there's an article, it's still in its draft form, written by engineer Woon Chi Keng, and he actually suggests that the Temporary Measures Act, the COVID Act that we've been talking about, Act 829, is also a social piece of legislation. So if you've got one social piece of legislation over your HDA social piece of legislation, where do you think we are? So, Mr. Wee, would you like to touch on the universality of contractors, that we are not just dealing with our domestic and local players, but we've got others beyond our shores? Do you think these measures that you are taking would be enough to address those concerns?
I think nothing is enough. Nothing is enough. Like what I have delivered earlier, we are trying to soften and lighten the shoulder of everyone. It's individual decision, whether you think you can take it and move on, or you call it a day. Nothing is enough for anybody. That's what I thought.
I see. And Dato' Tan?
I think the 4 months given by the government is to ensure most of the projects are covered. You know, it actually make provisions for you to still negotiate for a longer EOT and also go on your contract provisions. If you can prove that your delay is actually more than 4 months, under the contract, you can still grant EOT beyond the 4 months. But the 4 months is going to help most of the contractors, you know, for not having to apply and submit all the particulars, right? And it will cover at least 80% of projects on ground. But it doesn't stop there.
But you
There's
think
still provision.
our overseas players would comply as well?
Yeah, I mean, we treat all our contractors the same way. They sign the contract based on PAM form. So whether they're from overseas or local, we all treat them equally. So it doesn't really matter.
Thank you. So Dato' Som, as far as the social piece of legislation is concerned, do you agree with Engineer Woon's comment?
To me, I think we need to look at the whole issue of the day. It's something not due to the fault of any one of us. So I think there need to be, when you want to say social legislation, you are going to help the poorest and the most vulnerable party. Here is like every party is vulnerable. Every party is actually affected. So I think we need to have this fairness. It shouldn't be just look at it from a point of piece of social legislation. And at the onset, when we decided what should be the period given for the exclusion period, I don't want to use the word EOT. It's a taboo word for developers. When I'm sitting in the master builders, I talk about EOT. But when I'm a developer, this is a taboo word. I learned already. I have to zip my mouth on EOT. Because once I say that, the court will come and slam after me. So I have to say the exclusion period now that has been given, has been discussed at length in BIPC as well. We had a meeting, I still remember, in Wisma Reda. PAM was there and the master builder was there. And we agreed to a certain period and the way we want to do it. But when the act was formulated and enacted, the whole thing got distorted. You know, it was totally out of shape and didn't take in our recommendation as well. So to me, it has to be equitable and what. And then can I just comment on the international thing? I think our COVID Act never addressed issue that happens overseas. Okay, and you must remember the supply chain I talked about. We have materials coming from overseas. We have professionals, the expert for installation of certain equipment coming from overseas. We have also contracting parties that issue LC to the overseas. And because of this period, because of the rights, just now I talk about obligation and rights, because they want to exercise their right, they then cash in on LCs and bonds. And it has already happened, I know, because somebody called me about it, and it has already happened. So this is also a flaw in our act that doesn't cover the overseas jurisdiction.
Right, thank you. Very real and grave concerns. But while I've been asking questions from the very, very interesting feedback, I understand that we've got questions from our captivated audience. And we also have questions, I think, from the next panel. They're all shifting in their seats and waiting to ask their questions. Right. First of all, can I just take the question from the audience? And there's one from Ezumi, would you like? All right, I'm going to read this question. It's from Fang Lim. It's indicated that what's not been addressed here is the role of the local authorities in addressing the problems that have arisen from the C19 problem in our construction industry, deadlines for licenses, etc. The approvals due to these local authorities delay because they've not been sitting or working. What's the position as far as that's concerned? Dr. Khan, would you like to address this question?
Actually, I addressed this problem yesterday in the talk under the LAM webinar, because today's the focus is actually on construction contract. It's definitely true that we have a lot of problems with the local authorities, and we're actually appealing to the government during this pandemic period, whether the government and the local authorities can be a bit more sympathetic in the way they process our plans and give us faster approval process. But unfortunately, we are hitting a blank wall. Authorities are not entertaining physical discussion. Submissions online has been made difficult because we have to make appointment to submit our plans. Discussion with authorities hampered the approval process. And I was just sharing with some of my friends, my plans got rejected by Bomba 5 times. So I added on to that statistic because they are not able to see us, we are not able to discuss the problem. So this is a real problem. And probably Ezumi later can also highlight. In fact, in many of the presentations even under MPC, we're appealing to government to go online, right? Initially, when MCO came, we actually wrote to Bomba and said, can we facilitate a discussion with you online? Since you're so worried about the SOP, right? Why not have it online? But they say they have no facilities to do so. So the entire liaison with the authority has been quite painful, I must say. And I can't solve the problem. We can only bring the problem to KPKT and the local authorities. But end of the day, it all depends on individual local authorities as well. I'm dealing with Majlis Sepang, but they are very good. In fact, the moment we submit our plans, they give us almost instant approval. So there are some local authorities who are very accommodating, whereas there are also some that have been very difficult. So end of the day, I have no solution. We can only through PAM and through LAM, bring it up to the higher authority and hope that the government can help us. Yeah.
Thank you. The solutions and the answers to these questions posed do not necessarily have to come from the panel here. We've got a second panel out there, so distinguished, even more brilliant, perhaps they would like to share. Anyone? Joseph? Yeah. All right. If not, I'm going to move on to the next question, which is posed by Alphonsus Tan. And this is about the proposal to exercise some leniency when we are implementing the CP under clause 23. Would that cause some kind of confusion?
I think this is quite interesting because even among ourselves, we're arguing whether my original proposal is waiver, but we were arguing whether waiver or leniency is actually a more correct term. But end of the day, we're saying during this pandemic, under PAM form, we have very strict compliance, condition precedent. So if you go strictly according to the contract, if the contractor does not give us the notice and did not submit all those things in time, we can then just say, you're not entitled to EOT. But we are also saying, we are going through a very difficult time. Contractors are also suffering. We are being hit and none of us expected it. So maybe we should take a more lenient way in dealing with the application, right? But we also don't want the contractor to not at least submit enough particulars to help us to do the application. So we thought maybe leniency is not leniency, more lenient is a better word as compared to complete waiver. So contractor also needs to help themselves. We also will try to help, but end of the day, you must also give us enough information for us to help to assess the EOT. That's why we decided the term to be more lenient rather than a complete waiver.
Time doesn't permit us to offer the opportunity to the second panel to ask questions. They will have to reserve all those thoughts to the time when they take the stage, and then we will make sure we will ask the questions. I'm only going to summarize by saying that the brigade is here. The interested parties have also been the affected parties. They are no longer sitting idle. They have said to themselves and to others, enough is enough. We have to do something. And it's no longer talk, but putting their thoughts to paper. The practice note is going to go out there. It is entirely up to you how you are going to vote. Vote wisely, vote carefully, vote not for today, but for the long-term industry. Please join with me in thanking these three eminent speakers who have done nothing but to share and to try and resolve. Thank you.
Thank you very much, Yang Arif, Datuk Mary Lim. And also, thank you very much also to the panelists, Datuk Architect Tan Pei Ing, Datuk Engineer Som Heng Chun, and also Mr. Oliver Wee. We will now take a short recess for about 20 minutes. As was mentioned by Anthony in the beginning, this forum will be split into two sections. So the first section has already ended. The recess will take about 20 minutes. Don't go away. We have something in store for you. There will be slides playing. And we will resume back in about 20 minutes from now. That will be about 11:25. Stay tuned, and we'll see you back soon.
Assalamualaikum, kembali bersama saya Syami Johari di Neon TV. So sekarang kita berada di Street Furniture Judging yang berada di berdekatan dengan Bazar Revo. So beside me is landscape architecture, which his name is Pei Yang.
Yes.
Alright. So what is your opinion about street furniture?
Oh, I think it's great, to see so many entries, not just from local universities in Malaysia, but also from Indonesia. So I think it's great, we have all this, such diverse people, with a lot of very diverse ideas, exciting ideas, coming together, just to celebrate, this a festival about the built environment.
Thank you, Piang. So that's all for today. See me next time on Neon TV.
And the second session of the PAM Professional Practice Forum. The second session will be moderated by Yang Arif, Datuk Lim Chong Fong. And without further ado, Datuk Lim, over to you.
Thank you. Good morning all. Welcome to session 2. And we have had a very interesting session 1. So I hope likewise session 2 will be interesting. Now, first and foremost, I'd like to thank PAM for inviting me to moderate this PPC Forum 2020 roundtable. Now, as we have heard in session 1, 2020 has been a very turbulent year. And the COVID-19 pandemic came and gravely affected everybody in the construction industry, particularly in respect of work performance and construction payments. Now, we have the COVID Act, as we have heard in session 1, enacted in October and also coming to force in October of this year. Now, between the period of March till 31st of December, which is basically the period covered under this Act, as far as construction disputes are concerned, where we all know construction industry is a dispute-prone industry. Now, from the courts, it looks like the statistics of cases remain high, even in the 9 months from March to December. So the construction courts in KL actually registered in excess of 400 cases over the period. Well, we have today, in session 2, the topic navigating the new normal, including and in particular the COVID Act of 2020. And with us, we have 3 distinguished panelists who will be speaking on this topic. Firstly, we have Mr. Chun Hong Ling, an advocate and solicitor. He's a partner in Raja, Darrell and Low, in charge of dispute resolution, construction, infrastructure, and energy. And I think from his CV, I've checked in the website, he delves into intellectual property cases too nowadays. Hong Ling has 17 years of professional working experience. He is the Vice President of the Chartered Institute of Arbitrators, Malaysian branch. Personally, I've known Hong Ling for more than a decade. And Hong Ling has appeared before me in the interesting Mega Sasa case on the constitutionality of CIPA as amicus curiae of the court. And he has also recently appeared before me in an interesting adjudication setting aside case involving Section 4 of the CIPA. Besides Hong Ling, the second panelist is Mr. Rodney Martin. He is a chartered QS with legal qualification. He is the CEO of Charlton Martin Group, and the group is a specialist in, or Mr. Martin himself is a specialist in construction contract consultancy on contract documentation, contractual claims, dispute avoidance and resolution. Rodney has 34 years of professional experience, and he's also an arbitrator, mediator, and adjudicator. Again, personally, I've known Rodney for more than a decade. I have had the privilege of being his opponent in an arbitration where we were on opposite sides. As well as I think I cross-examined him as an expert witness in the Smart Tunnel arbitration years back. And thirdly, we have Mr. Joseph Tan Meng Hui. He's a professional architect and principal of Tangent Design. And Mr. Tan also has 30 years of working professional experience. And he's a member of the PAM Contract Review Subcommittee and involved in the drafting and review of the PAM 2006 and 2018 contract. I must confess that Mr. Tan is a new acquaintance to me. I've only met him 3 hours ago. So yes, these are the panelists we have this morning. Now, as to the flow sequence, it will not be very different from session 1. I will be first inviting Mr. Chun to make his presentation, followed by Mr. Rodney Martin, and then Mr. Joseph Tan to comment on the first 2 presentations. And thereafter, we will have Q&A sessions from the audience or even from the floor here. So without further ado, may I invite Mr. Chun to make his presentation.
Thank you, Judge. Thank you for the introduction. And good morning, everybody. Thank you being with us for this forum. What I will look at is the issue of disputes. I mean, we know that disputes are there and it's getting worse because of all the uncertainties that we are facing today. And it's probably going to roll on because we are also looking at the constantly changing and evolving situation. We don't know, I mean, notwithstanding the vaccine news and all these things, we don't know when this is going to end or how it's going to end. So with all this uncertainty, it is foreseeable that not just we are dealing with past dispute, whatever that has been in the past 9 months or even more, but certainly we are also looking at how do we move forward from here. From what I could gather is that ultimately, this will not be a win-win situation. We know that, okay? But how do we minimize the disruption and how do we minimize the losses so that everybody will be able to still live on with it? And to me, the benchmark that I'm setting here is that how do we ensure that whatever we are doing in terms of our projects can continue to the completion, because that must be the objective of all the stakeholders, be it employer, purchaser, contractor. That must be the objective. So how do we move forward and make sure that that can be done? Sorry, the clicker is not working. All right. So what are the scenario that we are looking at? I would like to think that number one is that it hits everybody. I mean, let's not get away with it. It hits everybody. And because of that, the time and money impact, somebody will have to foot the bill somewhere or jointly footing the bill. And the question is, how much share each of us take? Or if in the extreme situation, which is the fall guy out of the entire chain. So the impact is real. And because it's unprecedented and with great deal of uncertainties, it creates also a degree of legal uncertainties. So we talk about COVID-19 Act this morning. We talk about the insufficiency. We talk about some confusion that it brings about. That potentially opens up a new area of dispute. Also, how do we interpret the contract, the PAM contract? How do we exercise the right? So all these things that which previously we may not be facing, we will be facing it now. It's the PAM contract, say for example, force majeure clause, you have the epidemic. Is it enough to cover what we are looking at now? So COVID-19 Act, very simple, Section 7 talks about it's its inability to perform. So how do we construe this word inability, which sounds like a very high threshold? And it only limits to measures taken under the PCID Act. So how about the impact of COVID-19 in general? Does it fall within the Act or it doesn't? So there will be new boundaries that to be drawn and new battlegrounds. And with this legal uncertainty, it will take some time for the legal process to reach a certain level or certain degree of certainty. You know, it will have to go through the court. The courts will have to take the opportunity to give certain definition, certain interpretation. But while this process is taking place, dispute doesn't stop. Disputes continue to happen every single day. And it is not something that parties to a contract will have paid attention to in negotiating the contract. So this morning we heard that, look, PAM did not have this in mind. Obviously, nobody had this in mind. When we put those words in epidemic, we probably think about, you know, maybe a seasonal flu for 2 months somewhere. That's about it. And force majeure clause is probably a clause that is the easiest thing for you to negotiate on that, okay, no, let's just sign on it, forget about this. You know, you just take a boilerplate and just chuck it in somewhere. So it's not something that people actually address their mind. And that makes even you want to interpret the intention of the parties difficult because it's not something that parties actually address their mind to. And because it's a constantly and continually evolving situation, we may end up like a shadow chasing, that whatever that we are doing is always 2 steps behind time. And disputes usually happen in such a way that once you take the first wrong turn, then likelihood is that you will be on a slippery slope and it will just start to snowball and go down. So the difficulty of making that right turn now is challenging. And that may end up parties not even taking a turn at all. That's when decision could not be made, or we don't know how to make that decision, which way to go. But like I said, the life has to go on, project has to go on, role has still to be performed. So what parties will have to brace for is certainly more dispute and consequently more engagement of dispute resolution processes. The financial pressure and the increased default insolvency risk will also hasten the trigger in the sense that people may be patient before this because we are all in the same boat, we all suffer. But when cash runs out, when you need to put food on the table, that's when pressure will come. And no matter how unfortunate I think you are, but I will still need the money. And if I can't get that via the normal, talk and all these things, then certainly legal action or legal process is a very likely situation. So, but we also have to face with this reality, which I would like to let everybody know, that winning the legal battle may be the easiest thing to do, but actually recovering the money will be the true challenge. So we have to always take that into consideration. And with the SIPA adjudications backlog that we know that for the past 9 months, because the appointment issue, so there weren't any adjudication case, or pretty much it gone quiet. With the appointment of the director, where appointment process are now started to flow, certainly there will be a backlog to clear. And with that, you will also be looking at the concurrent arbitration or litigation proceedings that you are doing it because maybe as a defensive mechanism in concurrency with the adjudication. And we are also looking at, after the adjudication decision has been rendered, you may still have the issue of enforcement, setting aside stay. So again, we are looking at that kind of problem, that it becomes a very hostile and sometimes, I say, it becomes a very litigious environment, that it looks like everybody is claiming and suing each other, and that's not good moving forward. And because it becomes very hard to broker any settlement when people become so wary, that relationships start to break down. So when all these things happen, we must also bear in mind that the reality check eventually will come. Okay, and we should therefore focus on that, and that is what I would like to propose, because there are limitations and constraints in the confrontational type of dispute resolution processes. Okay, because litigation process typically is frozen in time. That I sue you today, I base on what I have today. But by the time the outcome comes out, if you're lucky, in 6 months' time, 9 months' time, sometimes in 3 years, 4 years, that may well become irrelevant. It doesn't help you to regulate how you want to move forward with your project. It doesn't regulate how you want to move on with your life. I mean, let's put it this way, if 3, 4 years' time, whatever decided on the pandemic is still applicable, then we are in deep trouble. So certainly this frozen in time litigation is not going to solve what I always perceive as the ultimate objective, which is to get on with life, finish the project, so that everybody gets something out of it. The second point that I would like to look at is also this. Now, we know that this is something that strikes everybody without fail and totally unexpected. We say that we need to be fair, we need to be reasonable. But we must also understand that going through a formal legal process, there are boundaries and there are parameters. The judges cannot rewrite a contract for the parties. If that provision is not there, you do not fall within the act. It's hard for the judge to go too far and say, I think this is a just decision, although the contract say otherwise, I'm going to decide this way. It's difficult, okay? So because of this constraint, there will always be this conundrum of, are you reaching a conclusion based on what the contract say? Or are you really trying to achieve so-called fairness? And even that fairness, I would like to say, is a perceived fairness. And in many ways, depending on which side of the fence you sit on. So with these restrictions and also the time and cost exposure in already a challenging environment, going through a formal confrontational type dispute resolution process doesn't seem to be the way forward. Of course, that process will have to go through. There's still a significant role to be played by these processes, but certainly that may not be the ideal situation. Then we start to think about, is that the awakening of mediation? Is this the time for us to really push through the mediation? And we all hope that the Act will probably do something that create that environment. But I think in this morning, we already heard about the COVID-19 Act. Mediation under Section 9 may be settled by mediation. So again, it's not compulsory. And then we also talk about a situation where this Section 9 is in relation to Section 7. If there is a dispute arising from the inability to perform because of measures taken under the PCID Act, then you may be settled by mediation. So it's a very narrow scope, I would say, even within this regime, it's a very narrow scope. And the difficulty here is that if one party has already taken the view that I do not need to perform, the compulsion to even go for mediation will be much less. Well, I mean, if the Act says that I don't need to perform. I can be excused and say that you disagree. You want to mediate with me. Why should I? You know, where is that incentive? Where is that encouragement? Why don't I just wait for you to sue me and bring it before Justice Lim and decide whether or not, you know, I'm liable? So what is that compulsion that I'm going there when the act already said I don't need to pay you, I don't need to do this? Because I know that going into mediation, that means I will probably have to pay you something or be in a weaker position than I think I am in today. So the act doesn't really create a compulsion, incentive, or encouragement. The way I read it, it seems more like, hey guys, remember, there's still this mechanism called mediation. Don't forget about it. Use it if you can. So it doesn't do much more than that. That's how I perceive the mediation regime. So, but other than we talk about the general way, the arbitration, litigation, adjudication, and mediation, what other ways that we can look at, and how do we self-help in that sense? I like what the speakers this morning talk about. The industry has to do something. We must join forces. So what can we do? I will look at this in these two prospects in the sense that the micro and the macro aspect of it. The micro aspect is where it's driven by consultant, meaning the contract administrator, the architects, the engineer. Not necessarily it must be the SO. No, it can be any consultants. Because we must realize that, number one, consultants, a lot of times, they are already playing that mediator and arbitrator role. They know what is happening. They always try to tell parties that, why don't you try to settle on this valuation? You know, you want 1 million, you want 1.5. Why don't we sit down and talk and come to a conclusion? You are already playing that role in a way. But if you cannot decide, I still got to make a certification. So I am, again, also playing the decision-making role, the arbiter role. So you are already doing that. So that's why consultants are in a very unique, multifaceted position, because you are authoritative, you are well-educated, well-trained, professional, you are powerful, and you are influential. So there is a greater role for you to play, whereby clients will typically give due weight to advice given by consultant, especially if we talk about, for example, maybe if I could just go through the next slide to say that if we can help to focus our mind into how do we move forward. Now, we have a lot of disputes happen until today. To resolve that, probably is going to be difficult. To have a settlement on that, probably is going to be difficult. But why don't like this? We are not waiving any of these rights. You want to sue, you want to claim, let's come later. That's fine. But let's have a clean start, a fresh start. So now you know this is the COVID-19 pandemic. Contractor, tell me, how much more time do you need from now on? Tell me, to comply with all this, what is the cost that you need? Forget about what is in the past, because that one, I would consider is much harder. But let's look at, from now on, moving forward, what kind of time and cost exposure that the contractors are looking at. So I think that will be the easier basis to work out an acceptable solution to both parties, whereby, at least number one, insofar as the owner is concerned, you have better degree of certainty that at least this project can finish. You will still get the end product. You can reduce the moving forward default risk. Number two, the contractor, again, will have a better chance of knowing that even at least from now onwards, my risk can be better mitigated, because now we know we are facing with this. So to me, it may not be entirely the win-win situation in a very traditional way, but certainly it's a less loss situation to both parties. And why this cannot happen a lot of times, I find that is because we are so stuck with the past disputes. Okay, we are so stuck with situation where I know that the whole delay is 9 months, but actually 6 months of that, nothing to do with COVID-19. It was your own default. So I'm not going to give up that right. And then contractor will be thinking, oh, if I don't now try to push for all these things, then I may lose my chance. So I also continue want to fight my corner. So parties are actually still focusing on how do we resolve the past instead of looking to the future. So if we cannot resolve the past, so my suggestion is that you segmentize into that, you freeze that, parties are at liberty to reserve their right, but let's focus on moving forward. And because when you start to focus on moving forward, then the consultant can step in and say, come on, this is the realistic worst case scenario, is that you may have all the rights in the world, but if this contractor go under, you're not going to get your project. As simple as that. Sue them if you want to. You will get a paper judgment. Fight for 3 years, 4 years, 5 years, spend all this money, you will still not get the money. So let's get real. moving forward, how do we overcome this? And more creative solution can be brought up during that stage because you're doing treating it like a new relationship moving forward, as opposed to getting burdened by what happened in the past. You can have payment restructuring. Like I say, I would suggest that you can use guarantee in lieu of retaining actual cash from the contractor because you are still in a way secure. You can have advance payment, but again, you can have security over that because cash is king. Cash is important. So with this is where the consultant, I feel that they can do more to come in to say that let's move forward. Let's think of the forward because I can't decide the past, but doesn't mean that you don't leave, you give up any of your rights. So this is in a more micro aspect. In a more macro aspect, I would think that today we have all the stakeholders here, which is a good thing, and I think movement is already there. What we can do, I would draw this like something akin to, we will see this dispute resolution board in a very large scale infrastructure project, where the industries can actually set this up as a service. Because for the smaller projects, it doesn't make sense to maintain a dispute resolution board. It just doesn't make sense, But if you have this service that can be in a way outsourced, where the industry represented by everybody can have this panel, you have this center to provide this service where what the concern is, if you want payment and money, fine, you go for your SIPA, you go ahead with that. This one, the focus is how to get on with life, how to implement forward, not so much about you have a claim that has not been paid and all those things. So let's start with that because, like I said, only when the project is able to finish, that's when everybody will get something out of it. So the institution-driven resolution process, that's what I call it, that it can have a service that cater for a specific needs. SIPA is for payment, that we know. We are not trying to here to supplant SIPA. SIPA is fine, it will still run its course. But there's so many things else that we can do to give this temporary decision or guidance to ongoing projects, to ongoing parties. Of course, parties must subscribe to it, must be bound by it at least temporarily so that the project can go on. So that you avoid situation where you take one wrong turn and then you just go wrong all the way and it becomes irretrievable. So you can have a nip it in the bud solution that you can do it early enough. So the challenge is how to get the parties to sign up for it. But I think with all the industrial stakeholders here, we will have enough muscle and influence to get people to buy into the system. And there's only 3 criteria. If you can achieve these 3 criteria, there's no reason why people will not want this service, which is cheap, fast, effective. These are the 3 things that I'm looking at. If you have a way to do it, to say that 1 month, that's it. Whatever it is, if you're just talking about whether this particular cost, is it something that you're claimable under this provision, for example, 1 month, that's it. You decide on that, okay? And so that you regulate certain conducts moving forward. So, of course, how this can be structured, that is something that people will need to sit down and think about it. But as a concept, if it works in a large-scale infrastructure project, there's no reason why it cannot work in a smaller scale. Just that in a smaller scale project, it doesn't worth the investment in terms of time, cost, and expertise to have that kind of structure. So the stakeholders can actually have this service for the industry to buy into. So these are my recommendations or suggestions on how we can try to have different ways of resolving disputes. The usual ways will still play its role. No question about that. But I think because of what we are facing and because of the constantly changing scenario and situation, we need something that can react to it better and go to the issues quick enough, cheap enough, and to make it work. So thank you, everybody.
Right. Thank you, Hong Ling, for the very interesting presentation. I think basically Hong Ling focused on the need for reality check because the existing dispute resolution procedures don't seem to work in this COVID scenario. And Hong Ling also pointed out on the limited scope of mediation that has been prescribed under Section 9 of the COVID Act. So he has suggested perhaps segmented renegotiation, I call it renegotiation, on a without prejudice basis, preferably led by the SO. Maybe that's the cheapest way and the cheapest person to deal with it. Otherwise, maybe to emulate the DAB, the DAB in complex projects to undertake this task. Right. I think in summation, that's what I think Hong Ling has conveyed. Perhaps I'll get Mr. Tan to give his views afterwards. So before going over to Mr. Tan, next we have Mr. Rodney Martin, and if I could invite him to make his presentation on, I think the title is Insights into Foresights, if I get it correct.
That's correct.
Thank you. So Rodney, floor.
Thank you, Dato, and thank you very much, Pam, for inviting me to take part in this very interesting panel today. Indeed, my talk, if I can just get the slides up. Thank you. My talk is indeed entitled Insights into Foresights. I thank Mr. Anthony Tan for that title. He got me in to this panel because we talked together on other issues, and he thought I might be able to add something a little bit different from the very established and welcome views from the lawyers and the stakeholders, the office bearers of the various institutions we've heard in today. And maybe because I don't actually come from Malaysia originally, I've been here for 23 years, maybe I see a different angle. And what I wanted to do was just start off by saying what was normal. We've talked about the problems we've had because of COVID. It is a huge problem affecting our industry and, of course, everything we do in society and the world over. But I wanted to just go back 12 months ago, just for a short period, and say, what was normal before COVID? Well, we had in our industry what I say are well-drafted standard forms of contract with reasonable risk allocation. I don't say that because the contract drafters are present in this room and because I'm in the PAM today, but it's true. I think, honestly, there isn't much wrong with the standard forms of contract that we have in operation, particularly PAM. Of course, it's 23 years ago when I arrived, they were still using the 69 form, and that was pretty rubbish because it was out of date and it was based on the JCT 63 form, and the EOT clause was just horrendous. Now you look at the EOT clause, and of course it's extensive, and it's protecting both the employer and the contractor. And the form of contract is pretty good. I use FIDIC as an international form of contract, and it's equally as good as FIDIC. What's wrong with the contracts is the way in which they're used, or should I say, not used. Employers, consultants, contractors often neglect their rights, ignore their obligations, and fail altogether to administer the contracts. I do a lot of work advising contractors or employers along the way on live projects, and there isn't enough action. And I think this is going to be a theme from today, which the other speakers have referred to. There isn't enough action early on. Problems arise and they're put off. Contractors are told, don't put claim, don't be contractual. Why ever not, Mr. Employer? It's your contract. I'm just following what it says. But that seems to be a stigma attitude, which is changing. Things are getting better. But the contracts were not performed, and disputes are prevalent in our industry because of that. If the contracts are administered properly, if the contractors comply with the simple requirements of giving notices when they should and providing details and giving everything as and when the issues arise, a lot of time will be avoided in spending dispute resolution hours as we go forward. Relationships will be kept and so on. So in the theme, I guess I'm going to be picking on the contract administrators who, again, with parallels to FIDIC, could actually go in and negotiate with the employer a lot more than they do, consider the contractor's claim, and try and reach agreement and consensus as the claims come along during the course of the project. And there wouldn't be so much problem if that happened. The other issue, and this is really the main theme for my talk, is that the industry hasn't really yet wholeheartedly embraced technology as other industries have. Manufacturing, logistics, etc., have all embraced technology, and we haven't. And I really wonder why that is, because there is money available, as I'll go on to explain, in the industry. And if it's put in the right place, our methodologies could be so much more efficient, advances could be better, and I'm sure that would lead to fewer disputes in the type of products that we are producing in the industry. Yes, the forms of contract did not cater for pandemics. PAM's got the force majeure, which conveniently deals with epidemics, but generally our contracts didn't deal with it. But so what? Problems arise all the time. Yes, going forward, we may come up with amendments, we may come up with COVID or pandemic guidelines, but it's still up to the parties to be sensible and to talk and to deal with issues in a timely manner. So that's really one of the big issues, big points I want to make. It's about getting on with it, taking action. You can make a decision and be wrong, but making a decision is better than not making a decision. So when the architect is concerned about whether it should be so many days or not, he needs to get on with it, and deal with it, and not put it off and cause a bigger problem later on. So just looking at what was normal again, the second point, the industry was and still is the biggest industry in the world, but was not performing well. The ecosystem represents 13% of the global GDP, yet productivity growth over time was 1% per annum for the last 20 years, and the average in other industries is 2.8%. So the ability at which an industry becomes more productive and therefore improves through its processes, we're well down 1% compared to 2.8 as the average in other industries. As we know, time and cost overruns are the norm. Overall earnings before interest and taxes are about 5%. Now, most contractors, I think Oliver will be very happy with 5% today, but that's actually not very high margin when you look at the colossal risks that contractors take on in the construction industry, in the project. So we're not in a great shape. We weren't in a great shape as an industry before COVID. Now, COVID's come along and it's even worse. But there may be opportunity through adversity. Because of the circumstances with projects being put off, stakeholders deciding what their position is, there is a glint of light at the end of the tunnel. There is an opportunity for the radical change which our industry requires to be introduced. And this can be done in many, many ways, some of which will talk to the COVID-19 problem, such as reducing dependency on site for labor. With less labor on site, with more component manufacturing off-site, then we can reduce the problem of having exposure with numbers on site and operatives on site. Specialization in target niches and segments. The industry is populated with many, many contractors of different grades who do essentially the same thing. If we had specialization among different contractors, as we have in different countries, then that would improve efficiencies. Value chain control. Design and build contracting was a great opportunity for contractors to take the lead, embrace design, employ architects and engineers, and actually provide products which were innovative. But that didn't really happen. And my experience in Malaysia is that it hasn't happened. The design and build projects, which the government did embrace 20 years ago as a solution to delays and overspends, the consultants, many of them working for contractors, didn't realize they had a new boss. They didn't realize they're working for contractors. They still behaved as if they were employed by the employer. So design and build, I would say, wasn't very successful. But there's great opportunity in that model of procurement to actually improve the products that we produce in the industry. Consolidation through product-based approaches, looking at the fact that we build housing, it's a product, what does it stand for, how can we market that as a product, and not repeat the same issues of contractors having a bad reputation for defective work, and that's what I get as a buyer, that's what I have to expect, instead of actually brushing up and improving the products. And that's across the industry, of course. Customer-centric branding of design, construction services. Developers have brands, so why shouldn't contractors have brands as well? These are all potential areas where improvements in the industry can be made. And at this juncture where we're looking at the problem we have with COVID, We should be looking at the problems that we have with the industry generally to make it more efficient, to put the money spent to better use. Of course, investment in technology and off-site production is very important. There is some use, of course, BIM has been introduced in the last 10, 15 years to limited access. It depends on the ability to roll out BIM in larger projects and so on, but really there's a place for BIM in every project. And whether it's the consultants, whether it's the employers, whether it's the government pushing such initiatives, we have to get on with it. We have to embrace technology and we have to use it to bring in more efficiencies and avoid the terrible waste that we have in the industry. Investment in human resources. The next stage, the next generation will be digitalized. So we may not be, certainly anybody of my age may have to embrace digital technology in a different way, but the next generation has it at their fingertips. Why are we not using that in our industry? There is obviously a stop on contractors from Malaysia going overseas, taking their wares and their skills there at the moment, but in the future, once there has been change, of course, better contractors going out with better products and embracing everything that is new will improve greatly their chances of success. Sustainability is very important. Obviously, environmental issues, site safety, material selection. Again, we're well behind and we need to actually get on with producing those improvements. So, of course, there's a need for change in the way we do things, the way we administer contracts, the way contractors build, the way they house their operatives, the way they go about everything in construction. Safety issues are unacceptable, overspend, wastage, maladministration, all of these issues, these terrible problems that we have can all be considered now in the bigger context of COVID-19 and what we're doing next year to get on with it and move forward. So we have to have a bigger conversation. It's not just, and of course, the immediate discussion mainly today has been how we're going to get through this, how we're going to get through this next year, how have we dealt with the problem that's been introduced in the last 9 months and so on. But there's a bigger problem to be dealt with. And this is an opportunity to pause and have a go at solving some of these other problems. Of course, as I say, the realization that change is necessary, we know we have a problem, we haven't been very good at doing anything about it, and it's not new. And yes, of course, transformation will take time. It's not going to happen next year or the year after. It will take time, but we have to start now in order to improve. Can COVID accelerate change? Well, there's certainly a conversation. We're all here today seeing how we can overcome the problem. That conversation should expand. The construction industry is probably now in the perfect storm. If we compare with another industry that's gone through some quite rapid transformations, would be the auto industry. 1970s and 80s, there was industrialization, mass production of motor vehicles. 1999 to 2000s, globalization. So I'm not just talking about the Malaysian auto industry, which of course is great parallel, but internationally, around the world. Globalization in the 90s and 2000s, where domestic products were sold internationally, assembled internationally, to great success for that industry. And now in 2010s and 20s, it's digitalization, technology being driven in, partly through consumer demand, but partly because it's there and available, into producing better products. So if that industry can do it, why can't we? There's no excuse not to be doing it. These drivers are now impacting the construction industry all at once. We can't avoid that. So the potential to achieve necessary change in the industry is presented by COVID as a disruptor. We're all looking at what's happened, the massive impact it's had on the sites, to the industry, to cash flow, how government can come in, how institutions behave differently, and how each person in each stakeholder's organization can actually consider how to make improvements. It's unique, it's unprecedented, it hasn't happened before in our lifetime. It's an opportunity for us all to do something differently. So I just end with those thoughts. They appear to be quite somber thoughts, but I hope it's realistic.
these words from Charles Darwin: "It is not the strongest of the species that survive, nor the most intelligent, but the one most responsive to change." We have to respond to the changing circumstances in which we face ourselves, not just because of COVID-19, but also because of the poor state of our industry. Thank you very much.
Right. Thank you, Rodney, for your very enlightening presentation. I think to sum up, you pointed out what the old normals were, and then you've mentioned that with the COVID-19, the new normal, there is opportunity available through adversity, and radical change is required to various project delivery methods. And these inadequacies were already acknowledged even before the advent of COVID-19, but now it's the time to change. The time has arrived. Basically, just that's what you have presented. So if I can now invite Joseph to comment, maybe from a consultant's perspective, from what you have heard from both our distinguished guests.
Well, tough act to follow. Whatever they've said, I thoroughly agree with and sympathize. There's not much left for me to say. But I think Hon Ling's talk was very good because there's a reason why I've never met you, Datuk, because you see, as an architect, first of all, I don't do huge jobs like some people. And I always try not to have disputes. It's scary if you have a dispute. And this is something I learned in my second, I think when I first started working in Malaysia. You have a dispute. I still remember my boss, very wise man. He sat down the contractor, he sat down the client, and he said, okay, do you want to argue about this? Or do you want to just split the difference between what you're arguing with and let's move on? Okay, so I think this thing about trying to resolve things through negotiation, through reaching consensus, is nothing new. All right, architects should already be doing this if you want an easy life as a contract administrator. I find it really great that you have somebody who makes his life of disputes giving such great advice. That's why I really congratulate you on a very good talk. Okay? So the other thing, now this is a function organized by PAM, so I will try to address some of my comments towards my fellow members. Now, there is the contract, there's the legality, there's a method for resolving disputes. Architects, I sometimes feel you all want to hide behind the contract, okay? You want to hide behind the contract so that makes life easy for you. If you want to hide behind the contract, then you better make sure you know it better than the contractor and the employer. Unfortunately, that's not the case. Okay? I think Rodney has already dealt with this to a degree, in that employers, contractors, and unfortunately, contract administrators, we aren't sometimes doing a very good job. Okay? So I still remember when COVID, when the MCO was first announced, I'm in a few chat groups of which I think PAM President is one of the administrator, and some of the comments we get, what shall we do? What shall we do? And I remember paying in another chat group says, it's all in the contract for the MCO. Okay? Architects, you have to get your act together. Don't have to please keep on badgering President to come up with a practice note to tell you what to do. You all should know better as a professional. All right? Then moving on, this thing about evolving technology. Yeah, actually, COVID is a great time. It is a time for initiating of change. But unfortunately, in the Malaysian context, I think change is very, very difficult. We already know we should have greater IBS. We know we should have greater digitalization. But as already pointed out by Rodney, if you are going to give a contractor 5% margin, and that's on a good day, what do you expect him to invest in for the future? The industry in Malaysia, whether we like it or not, now Dr. Som has already shown big numbers. but at the end of the day, it's still very small. All right? We need a lot of investment. We have to invest in human capital. Yes, we need BIM. It will come. But yet we have a situation where we have BIM modelers who do not know how to design in detail. Same is the same way we have architects who maybe are not very well conversant with the PAM form. So human resources, I think, is a big issue. COVID-19 is a great opportunity, but unfortunately, I'm no expert. I have no idea how to make that change happen. All right? We talk about moving things more things off-site. Yes, that's already happening. I still remember in the early 2000s, the government decided that they would clamp down on foreign labor. They went around to all the building sites throughout the whole of Malaysia. And for a period of about 3 to 6 months, there was no activity. And immediately after that, what happened? All residential projects all started to invest in system form work. Okay, I still remember the date. Now, this is an opportunity for a similar change. We need to get rid of labor, not just foreign labor. We need to get rid of labor by upgrading it. But I go back. If you're giving the contractor 5% margin, what do you expect him to invest for the future? Okay, so this is unfortunately where government, I think, has the role to play. I shall also end off this because, like I said, I don't do big projects. But that is why I feel the ladies and gentlemen in this room are very, very important. In Malaysia, it's all trickled down. If the change doesn't come from the people who can afford it, who have the ability and the resources to institute the change, the bottom bits, which is where I bottom feed, it will be even more difficult. So please, gentlemen, if you want to initiate the change actually has to come from people in this room today.
Thank you for the very interesting comments given. So far, I'm not sure whether there are any questions from the floor. Yeah. Right. If I can have them, and then I will. All right. So whilst doing that, I have a couple of questions. It looks like these difficult times, and I think, like in my view, the COVID Act seems to be catching fire to try to put off the fire sort of solution. And like what Rodney has mentioned, there are actually many more other changes required to actually progress and advance the construction industry into the future. I think nothing of that sort is seen in the COVID Act. So that, I think, has to be an industry change, massive change in itself to achieve that. I hope that will come, but I don't think it will come by way of legislation. So that has to be the industry, as Joseph pointed out, the government, maybe to take the lead initiative to get done. I think it's going to be financially intensive to have that radical change happening. Well, I hope it does come. And with that, maybe, hopefully, lesser construction disputes as well. May not be good news for the construction lawyers. But I think maybe the reality of it, I've been in this industry for about 30 years plus, and I think mistakes are often repeated. That's what I noticed. So maybe with advancement, there will still be problems. Any comments on this?
Can I respond to that? Okay. Now, one of the things about the even during the pandemic, before the pandemic, now government likes to give direction, which is great. Okay. They tried, for example, to government projects, for example, you need to have a minimum IBS score. Similarly, there was actually talk that some local authorities would require all building plan submissions to use BIM, even though the Street Drainage and Building Act and the UBBL have no provisions for the approval of plans using BIM. Okay. Now, And then you get a lot of politicians, you get a lot of think tanks that say, I read somewhere a think tank said, oh, if you use IBS and BIM, you'll save 30% off your construction costs. Now, I think, contractor, I think if you look at that, you want to, well, I don't know, you want to laugh or you want to cry. Okay? Now, I think that's why action has to come from here, because really, I have a lot of faith in developers and contractors. If you all can think of a way to save money, you all would have thought about it long time ago. Okay? It is just that I think there is a lack of capital. There are a lot of things we can do. It's just that we need money.
I totally agree. It's about the cash. Can the government do more? It can spend some cash.
Well, I guess most contractors, I think I take the point that if the margin is 5%, you'll be lucky that you get to keep that margin or any part of that at the end of the project. So, I mean, that's the reality of life. And when we start to talk about, hey, let's introduce BIM, let's introduce this, the cost will be saved by 30%. So what employer is going to do? There you go, see? So I'm going to slash the contract price by 30%. Don't you want to do it? It's okay. There's another 50 contractors lying out there who is prepared to do the job. So one contractor told me that he put in his bid at cost price and he ranked 46 out of 50. So he said, how did the other 45 do it? I don't know. So, I mean, in a way, it's a problem that we have in this industry. That number one, we are always driven by price and probably price alone. So forget about, I think this morning we talked about sometimes we overcommit, the typical situation of overpromise and under-delivery. Come up with a program that I can finish in 18 months. When people look at it, they say that, yeah, this 18 months can happen if you have sunshine 24 hours a day. So otherwise, it's not going to happen. It's just unrealistic, but we don't care. Get the job first. We think about it later. We apply for EOT later. We hope for VO later. We renegotiate later, but get the job first. So this mindset and mentality got to change, where parties will need to be put in a very realistic position. And that's where, again, I say the consultant will play a better role. For the employer, of course, you can do it at half the price and half the time. I'll sign up now. And I'll be asking, why didn't I sign up yesterday? But I don't know, because and ultimately, I would think that I can still enforce the contract, okay, if things do not happen that way. So that is where consultant will have to play a more prominent role. And that's where I say the advisory, because we listen to the consultant. I mean, there's a role to play that you say, hey, come on, you may sign this, you may have a contract, right? But this is not going to happen. It's not realistically attainable. So let's get real. So I think this reality check is important, and the COVID-19 probably makes people to think harder about this reality check on both sides, both the contractor and the employer.
Right. Question, is it from? Yes, Datuk Mary.
It's working now, thank you. I will ask the question anyway, even though Hong Ling came with a quick response to Joseph's thoughts. I have two questions. One is to follow up from Joseph's comment about the 5% margin. For the purpose, since there's enough muscle, I think that's what Hong Ling said, there's enough muscle power in this room to call the shots and make the difficult decisions. Joseph, tell us, what should it be if it's not 5%? Realistically, you've been in the industry enough. Tell Oliver the good news. What if it's not 5%? What it is, after taking into concern the Hong Ling's remarks about that, you know, the cost saving when you come up with new methods. That's one question. The second question I have is actually for Hong Ling, if I can, Chong Fong, which is, we're telling everybody to now sit back, facilitate, and try and find some kind of resolution. Would that extend to the parties like your good self, who should also now look at a different role, and that while it, and certainly it affects your industry, very much the legal industry, the judiciary wouldn't be looking for more cases. But do you think now the responsibility of looking at conciliation and resolution here extends beyond these industry players, that it extends to people like your good self who have such an important and significant role to play. Thank you.
Oh, yes, I have an answer for that. The answer is keep it at 5% and the balance give to the consultants. No, I don't have an answer, okay? And unfortunately, this industry still works on the greater fool theory. Like you said, contractor prices at cost, there'll be somebody else dumb enough to price even lower. And the industry profits from that. But I don't know if they really profit because, let's face it, this statement has really been overused. You pay peanuts, what do you get? All right. So I don't know what it is. This is a competitive industry. I'm not sure what it is. But if somebody puts in a margin of 5%, and because there are so many other hidden costs, because there are so many other things which are difficult to foresee, I think as Rodney already mentioned, you'll be lucky if you can get 5% or even get a profit. So I don't know what it is. I don't know how to change the industry. But if we want to invest, if we want to have smart workers, we want to have an efficient industry, we really do have to relook it. And I have to say, developers are guilty to the problem as well. I remember when I was working on a project, ours was only a 27-story building across the road. My same client gave a 50-over-story building to another architect, and they were building it. I remember talking to the project manager who was working on it. So this one, what's the construction period? Standard 36 months. And you think, you let your consultants and you let your project team tell you you're going to build a 36-story building, a 50-story building in 36 months? Doesn't matter, contractor's problem. You also let yourself into this.
If I could just add to address that question, it's not really about the number. So it's not whether 20% sounds too high to be giving. It's about the risk associated with that. So if you're going to give the contractor all that risk and say, well, if none of that risk materializes, you'll get 5%. But if all of it does, you'll get a lot less. That's the problem. Because we would all say giving contractors 20% is too much. It's a perception. But it's about what we're asking contractors to do. And also, I think there's a role for the quantity surveyor to advise his client of what a reasonable price should be in the first place, about setting the right goalposts initially and not committing suicide commercially.
And from my point of view, or the profession that I'm in, actually I don't see our role very much different from what I talked about earlier about consultant being the facilitator. Just that we cover different areas in that sense. I can't answer you how much more time needed to complete this project. I can't answer you that question. But I can answer you, if you push harder, the project is not going to finish, and this is what you're going to look at. So I think, yes, having the discussion on legal rights, obligations, all those are important. But to me, why are we even discussing that? Because we are discussing that to try to project what you will get at the end of the day. That's where I say that a realistic assessment of the worst case scenario is always an important part of when we are giving advice. And to me, there are twofold to this. Number one is we must get the objective right. If the objective is, if you come and tell me that, look, I'm going to close down next month, so we say sapu what you can, just get, and I'm going to run away. Okay, I'm going to fold the company. Of course, that's different. We are talking about a different kind of situation. But if we are talking about a genuine situation that everybody get hit by that, then, like I said, the objective cannot be other than make sure that the project finishes. So to me, get the objective right. And whatever steps that you're planning to do, the second part, realize that this is your worst, realistic worst case scenario. Then whatever steps that you're going to do will be guided by that to see what is the best way to achieve that. Sure, as dispute resolution lawyer like Joseph pointed out, that we make a living out of people fighting. But, well, I mean, I think there is enough fights to make us survive that we can live with a little bit less. I hope so.
from the floor. Oh, there it comes. Right. Perhaps I'll just read it out for everybody's benefit. Question from Chen Lin Yo. Presumably, both contractor and employer consented in writing for certain conditions. This doesn't prevent them to go for litigation in the future to contest the adequacy of the conditions they consented, be it contractor or employer. I wonder what is the viewpoint of the court and what is the main consideration of the court over these matters. Thank you. I think it's for Hong Ling.
Well, I mean, if parties actually agree to certain conditions, then certainly that's where you say that you actually crystallize the risk and put it into writing, and that is where you will get better protection and you'll be safeguarded. Of course, lawyers being lawyers, they will always try to poke holes, especially when clients say that, look, try to get out of this from me. So nothing stopped them from continuing with that path. They will just need to go through the process. But if parties can agree and that is properly documented, then certainly it's like 80% of the problem solved. So, I mean, courts generally will give effect to what parties have actually agreed. You know, the courts is not there to, in that sense, rewrite things that are so clear that you already agreed to this. So that's actually the earlier points that I made earlier as well, that if parties, in a way, like stupid enough to say that I commit to this, then who are we, whether courts arbitrator or who are we to now say that, oh, actually, I should give you more time. It's just difficult to happen.
The exception's insanity, isn't it?
Well, yeah, of course, you know, you're drunk, you know. And
Right. Yes, there's another question here from, I think, Architect Chi Suting, I believe. Question is, PAM form expressly states that notice is condition precedent to entitlement under EOT. How does the panel view, and more particularly how, not me, I hope, how would Datuk Lim view a respondent's claim that this condition must be fulfilled in defense when an architect overlooks this requirement in granting an EOT pursuant to COVID event? This is in light of PAM passing a practice note to architects.
well, I think fortunately I actually have a discussion with Datuk Lim exactly on this issue. But of course, whatever I say doesn't represent Datuk Lim's view. We got to be careful. I think that's my advice. That's because condition precedent or whatever is stated in the contract is actually a bargain between the employer and the contractor. So a waiver of that will affect the party's right. So we got to be careful how we treat that and how, because it's also very factual. Okay, let's get this straight. It's also very factual. But if there's a requirement in the contract, we can't just say that now the architect has the power to just waive it just like that. So I think that more things need to be done in order to achieve that objective. We know where this is coming from, that, you know, it's difficult time for everybody, but employers, much as they will try to be lenient, but there will be circumstances where employer may not take that view, and then this issue of compliance with the condition precedent, whether the waiver in that sense is effective, will be disputed. That's what I can foresee.
Maybe if I have a chance to clarify that proposal, I think as what we have highlighted in also our practice notes, whatever recommendation that we have that is out of the conditions of the contract is subjected to the parties' agreement. So this is what we are recommending for the parties to consider. End of the day, you still need the two contracting parties to agree in writing of some sort before it can be done. But we are appealing to the parties that this is an unprecedented pandemic. No, we do have to have a bit more, what do you call that? Common sense, yeah. Common sense is the right word, yeah, to deal with the situation, yeah. So we are not asking the architect to exercise that rights without getting the consent from the parties, yeah.
So in a way, you're recommending to the employer that he might not want to impose that.
Yeah, we are recommending for the employer to allow us to still assess the EOT, even though the contractor has not complied with the condition precedent requirement with regards to application of EOT on COVID-19 delay. Not on all the other applications, but only for the delay caused by COVID-19.
So there's absolutely nothing wrong with that for the question given. There's nothing wrong with that approach at all. It's very practical and common sense.
Yes, correct, yeah.
On my part, for a non-COVID scenario on 23.1, I have a decision coming out soon. So watch the news.
Look for harbors.
Sorry, Song.
I think I need to correct my earlier statement. I think we are all suffering except the two gentlemen who are living out the misery of others. I think their businesses are doing well. And I would say the COVID bill actually is made for them, you know. And but that's not what we all want. We don't want people to go into dispute. And I think a question asked, I think maybe I addressed to Hon Ling, is like there's always a trigger point, okay, between the employer, me as an employer, and he as a contractor. What is this triggering point that you think can actually, you know, make the people come to senses before he take action against me or I take action against him? Maybe you have any comment on
I think two things. Number one, again, let's set the objective. If we are at cross purpose, then I think it's going to be difficult. But if we are committed to say that, look, whatever it is, let's try our best to bring this project to a completion. If we get this objective right, that's number one. Number two, we must always remember that even moving forward, there must be something in it for me. That it should not be a case if the more I do, the more I lose. That's when you start to say that, look, enough is enough. I'm not going to throw good money at bad money. Sue me if you want to. You know, that's when that trigger point is. So first thing, we got to get real here that you are not going to be able to escape from this pandemic. Unscathed, you know, in that sense. True. Okay, so there will be some losses. Okay, but what is the kind of situation or what is the kind of scenarios that you're looking at? So that's why I say if the objective is right, we want to finish this job. Okay, then we should do all things that is reasonably possible to achieve that. So, and I think even from an employer's point of view, like I said, ultimately, if you have a half-built project, it's worth zero. It's really worth zero. There's no value in it at all. Okay, for a contractor, again, it's only when you are able to finish a project, that's when your risk is at the lowest. Otherwise, your risk is always at the highest. So to me, these are the two sticking points that can tell both parties that if you do what I say or proceed that way, you have a finished project. Your risk at least is managed. I'm not saying that there's no risk. I'm not saying that you will get your money, but at least your risk is managed.
Well, I tend to concur with what Joe said, but it's high time for contractor to invest on technologies in order to move further. We are still relying on our own method to do plastering, breakworks. But these are the area that we lost out a lot of money and time. I'm quite sure that Zoom will agree with me that the quality of the plastering today, if we ever to have a chance of money to invest on robotic, automation, we could have finish the job faster with better quality. And of course, architect would have played a part to look at the buildability on design, like maybe we can get rid of the breakworks replaced by our gypsum board, this and that. Well, I think in this difficult time, it's a good time for us to realize what is not practical and what is practical. Thank you.
Right. Any other questions still from the audience?
The question, maybe since I'm in the, I hope when I ask this question after this, don't chase me away, the architects. One issue as an employer, I'm finding difficulty now is like brought up by Joseph just now, that we must now take the opportunity to embrace changes, and the change must come fast. Otherwise, all of us will suffer, continue to suffer, especially with the government policy of reducing foreign labor. So I've in many functions told the government that you need to tie reduction of foreign labor to productivity, future productivity. Example, like moving towards IBS, BIM, okay, and whatever other form of IBS, not just precast concrete, can be any other technology. Question here is, you know, we don't want the contractor, because I've done it before many times, and I've used BIM on my own for certain projects, but that's not effective, cost effective. What we want is when you start the project as a developer, you then decide my project must be on IBS, I'm going to use BIM, and I must submit using BIM, okay? And to what level of degree of what I want to do on the BIM, whether it's LOD 500 or 400 or whatever, that can be used in the facility management in future. Question, why do the difficulty I have now today is I can't find many architects or engineers who are able to do design using BIM, first thing, and they don't have knowledge about IBS. Okay, this is a question I want to ask. So I as an employer, I want to find, but there's only limited. I can find many lawyers. No, I throw a stone, I get a lawyer. But if I got this dispute resolution, I throw a stone, I can find a lawyer to represent me. But if I throw a stone, I want to find an architect who knows IBS, who knows BIM. There are very, very few. So how can the whole industry, again, I want to say, how can the whole industry supply chain actually reinforce ourselves to go out there to better improve things going forward? We're talking about going forward now.
I think, Judge, I would like to respond to that question. I think it's very, very good question by Datuk Som. Yeah, it is true. When you throw stone, you will never hit the architect's head because they are working very hard in the office. Okay, so what I'm trying to say that actually it is true that not many architects actually has adopt the latest technology, but there are a few of them which is already on this technology, building information modeling for the last 15 to 20 years. And one of the specialists are here, our moderator themselves. Yes, the issue why I say that there are not many, I think it depends on the industry itself. Okay? It is very much that, like what Ronnie mentioned just now, is that it is our construction industry is price driven. So not many people want to invest in the technology where there is no certainty that they are going to get the return of that investment, except I think a few players who are already ahead of the rest. They already invested in the technology, in building information modeling, and even get very involved in IBS for the last many years. So the other setback is that many of the architects, they like to sit at the back. They don't really go out and say that, hey guys, I'm on BIM now. Hey guys, I'm doing IBS. That is one of the reasons. So what PAM can do, in fact, now we are trying actually to bring more of this talent architect to go out there and speak. And I agree that, okay, this is the technologies that we need to embrace in future, especially under the current situation of pandemic. If we use this technology from beginning, the impact to the construction industry maybe can be minimized. But we are very much depending on the human labor. So that's why when this pandemic COVID-19 came to our shore, okay, and we are very much affected. So even the recent, if you know, the latest cluster actually is from the construction side. But I think this is where I think COVID-19 itself has triggered the button now for us to look back into our policy, the government policy, even the practice of the contractor, developer, and the consultant, maybe to look more seriously into prefabricated construction methodology, using automation so that everything can be predetermined and just assembled on site. Using BIM is also going to reduce. Okay, I predict that by using BIM, it may also reduce the dispute as well. The reason why you can see the biddability and the collaboration before it goes to site. So virtually you can organize, you can see what are the issues, what are the problems. That may also reduce a lot of potential dispute.
Can I also throw in my 5 cents worth? It's really only 5 cents. Actually, this BIM, I will admit, I'm one of those you throw out, it will not hit my head. Okay, because let's face it, I'm old school. In other words, I'm from last century, so technology is beyond me. But talking about IBS, all right, now this one you have to address to the QSs. You sit down and you do your, let's say you're doing your costing. At this stage, for most jobs, no matter how you look at it, conventional, the costing will still end up being cheaper than IBS. So that's one reason why there is, it's not that well received. Second one, IBS, a lot of developers, they say, so how many suppliers? A lot of IBS systems are proprietary. they are fearful of being tied to that just that one supplier. So there are things the industry has moved on. The first IBS systems, government again, JKR inspired. The quality was terrible. Okay, it's moved on. Quality now is very good. We have IBS precast RC structural frames. All right, but again, there is also another layer. The system is going to be proprietary because the jointing systems are also proprietary. So there is always this fear, because now, for example, if I specify a brick wall, I can get bricks from anywhere. I specify a window, I can find equivalents anywhere. If I specify at day one a particular IBS system, like this building has got very, very fantastic flooring precast system, bubble deck. If I put that in my drawing, a lot of clients will say, so only one supplier. Are you sure? That is also part of the problem.
I think it's just to respond to you, there's a chicken and egg. And then the other thing is, I think it's for the good of the industry that we must now understand. I mentioned earlier, given the pandemic, COVID-19, government policy in Malaysia, we don't allow foreign labor to come in until December. It's going to be extended until June, and it may be extended further. And yesterday I was in a board meeting, we're talking about 1-for-1 exchange, you know. You want to bring in one foreign labor, you go to the detention center, find one who came in without any documents, you pay for his journey back home, then you bring another guy. I say, what nonsensical thing is this? And we agree that we need to reduce the foreign labor here. And at the same time, you need to encourage people. That means, I always use this word, forced persuasion. Forcing people in one way, but persuading people in another way. So the persuading part, I think the government need to see what incentive they can give to the developers. Don't give just incentive to the producer of components and all that, because it's all start from the developer. So you give the incentive to the developer. Example, give them non-financial incentive, additional plot ratio, you know, of half or whatever.
Oh.
Which, I mean, those are things. And we actually got some of it through. And I think we are in the midst of a discussion to say that it has to be all the way. That means the government must have a 10 years roadmap to say reduce the foreign labor by 50%, example. Okay, IBS score increase, but from then till here, I give you all these incentive. And I know the levy is going to increase for foreign labor, and they're talking about multi-tier levy. So you can do all that, but at the same time, be very transparent so that I know if I bring labor in 5 years' time, it's going to cost me this amount of money. As both a developer and the contractor can tell the developer, hey, construction costs going to go up if you use the conventional way. Hey, why not we all move towards this? And you mentioned earlier, I think Rodney did mention earlier, why not you as a contractor propose to the developer, hey, your budget is this, I do a design and build for you. I have done it. I've got a few jobs based on design and build. You know, because the client has this amount of money. He said, I cannot spend more than this. Then I throw everything to me. I have a look at it. And when I went back with a lower price, he said, okay, well and fine, you got a job. I don't even have to tender. So these are opportunities, but I think we all must work together as the supply chain. And it has to start, because I always say, developer being the top of the chain and the architect. Because without us, you know, coming forth to do this, the contractors are just following. But we hope that contractors also can take the lead and be on top as well, to come in to propose the design and build.
Thank you, Dato'. Do we still have time for one last question? I saw one on the screen just now. Right, this is from No Aisha Arif. Question is, client terminated architect, but not willing to settle architect's fees, which as promised earlier, without release letter from architect. Client retendered the project, which already is 80% completed, and new architect has been selected. Question, client never reply letter from previous architect, never want to reply all the letters. What action can previous architect take?
Yeah, maybe I can answer the questions. Actually, this one relates to the board. So board has got very clear guidelines on letter of release. If the first architect has been appointed, right, and the client has not paid his fees, the client actually cannot engage a second architect without getting a letter of release. It's a breach of code of conduct. So the first architect can file a complaint with the board. the board will take actions against the second architect who has agreed to take on the job without getting the letter of release. Yeah. But this one has got nothing to do with COVID-19.
Thank you, Dato.
Yeah.
Right, looks like I think it's time's up. So I think we have certainly had a very enjoyable session too as well. And I think what's left is perhaps to thank the panelists for the excellent presentations. And can we do it in the traditional way? Thank you. And signing off.
Thank you. Thank you, young Arif, Dato' Lim, and all the panelists. The session has ended. So I would like to have all of the panelists who are already in the hall to remain for photo session. For all of you viewing, 2020 has been a very interesting year in a lot of ways. We are now living with the pandemic, and who knows how long this will last. We hope that everyone will remain positive, objective, and persevere during this challenging time. We are looking forward to see improvement in the construction industry and also in our daily life. We are also looking forward to 2021 as we hope for the better future. PAM will continue to host more events, and the next upcoming one will be the PAM CPD Unlimited, happening on January 9, 2021. For those interested, you can go to pam.org.my, or you can also go to the PAM channel on Telegram, and you might also be interested to check out the new PAM application, already available for viewing on Apple App Store and also Google Play Store. So to all viewers and also everyone here in the hall, thank you very much. It's been great having all of you here this morning. So stay safe, stay well, and for those celebrating, Merry Christmas, Happy New Year, and have a good day. Thank you very much, everybody. Good job.